proceed.
Under oath, Brigadier.
Yes, my lord, thank you.
Yeah.
Yes, it please the court, my lord. Morning again, Brigadier.
Good morning, Advocate Minister.
Remember, we were still busy with Exhibit JJ. I mean, Exhibit J, I'm sorry.
Yes.
Exhibit J.
Yes, I remember, my lord. Warrant of sustained comes statement.
Yes.
Yes, I remember, my lord.
Yeah. Now, she had an interview already with the first witness, who was Khumalo. Then the second witness that she interacted with was Zandi Khumalo.
Yes, my lord.
Yes.
In first speed, akhuluma naye kwakusandi Khumalo tiye.
Now she says Zandi Khumalo, this is what she says in page 4 of her affidavit. The second witness was Kelly's sister, Zandile Khumalo. She told a similar version and gave a similar profile and facial description of suspect A. The only feature she adds was the eyebrows. She saw the eyebrows when suspect A lost his headgear during the scuffling with the deceased. She could not describe the second suspect.
Uthi guy, mechaza lapha. Uthi wachaza into efanayo wasenika incazelo echaza ngobuso bakhe kamsolo uA. And into ke athi yahluka lapho ayinezezela lapha amashiya. Uthi wabona ukuthi ususpect umsolo uA wasuka lento ayigqokile ekhanda ngesikhathi bephushana nomufi.
Oh, sorry. No, got it. Yes, I see that, my lord.
You follow that exactly.
Ngiyabona le.
Now she continues to say, the third person that I interviewed was Tumelo Madlala,
Umuntu wesithathu ke ngamkhulumisana naye uTumelo Madlala,
who was much traumatized.
owayehlukumezekile kakhulu.
He saw the scuffling between suspect A and the deceased.
Uthi wabona udonsana phakathi kwamsolo A nomufi.
After hearing the gunshots, he ran off to one of the rooms.
Mayezoqhubha isibhamu wabalekela kwelinye lamagumbi.
He gave a similar description of suspect A.
Futhi naye ke wachaza umsolo uA ngendlela efanayo.
I showed him Kelly and his sister's complexion and was satisfied with the ID kit.
Mina ngamkhombisa ukuthi uKelly nodadewabo banikeza ngani wasethi ke wenelisekile ngalo mdwebo lo owenziwe.
He could not compile the second suspect.
Athi ke ubengakwazi ukuchaza umsola wesibili.
The fourth witness was Mr. L.S. Twale.
Wesineke kwaku ubaba L.S. Twale.
I surmise here that this should have been Mr. Longe Twala.
Lana ngicabanga ukuthi kwakulongwe Twala.
Nonetheless, Miss Steenekam says he gave me a similar description of what happened at the scene.
Wanginika incazelo efanayo ngokwenzeka endaweni isigameko.
He saw the scuffling between suspect A and deceased. After hearing the shots, he ran out to look for help.
Wabona ukudonsana nosunduzana phakathi kwa-suspect A nomufi. Emva kokuzwa kuqhuma isibhamu wabaleka eyofuna usizo.
He could not describe the second suspect.
Akazange akwazi ukusichazela ukuthi wayenjani umsola wesibili.
Now she goes on to interview the fifth witness, who's Tim Makaleni.
Aseqhubeka ke nokukhuluma nofakazi wesihlanu Mr. T Makaleni.
But we know that that Mr. Tima Kaleni was not one of the witnesses who was in the house.
Siyazi ukuthi uThima Kaleni akuye nomunye wofakazi ababesendlini.
And then she goes on to talk about the sixth witness that is called Piwe.
Yaqhubeka ukukhuluma nofakazi wesithupha okuSiphiwe.
I will not waste the court's time because there's no name that is mentioned to be one of the witnesses who was in the house.
Futhi angeke ngidlale isikhathi senkantolo ngoba akuyena omunye ofakazi ukuthiwa bekhona endlini.
Then the last paragraph on page 5.
Manje ke paragraph egcina lapha ekhasini lesihlanu
says Lieutenant, oh no, it's COL Streichner, or it's Colonel Streicher, and I left for Fosloris detective to see Mrs. Khumalo at her house.
Mina no Colonel Streicher sasuka eFosloris detective siyobona uMrs. Khumalo endlini yakhe.
Now I surmise that this Mrs. Khumalo should be Kelly's mother. That's Khumalo, the one that we're referring here at court as Khumalo.
Manje lana ngicabanga ukuthi uMrs. Khumalo lo khulunywa ngolo esithi uMakhumalo okuwumama kaKelly.
I interviewed Mrs. Khumalo at the neighbor's house.
Ngingakhuluma noMakhumalo endlini ke kamakhelwane.
She gave a similar description of suspect A.
Naye ke wachaza umsolwa uA ngendlela efanayo.
I showed her that compilation and she saw a likeness in the face.
Ngabona ke mkhombisa ke umdwebo wathi wabona ngathi kukhona ukufanana la ebusweni.
She could not describe the other suspects.
Akakwazanga ukusisiza ngokuchaza ukuthi wayenjani labanye ofakazi.
Now yesterday when I put it to you that did you in your investigation find a witness who was in the house who describes the first suspect, that is the gun-toting suspect, in a different way from which the witnesses who were in the house are describing him? You said yes, you can go and look at, if you afford an opportunity, you can go and look in one of the statements because we're quite sure that such a description is there. This is the opportunity. Did you find anything which is not similar to what Mrs. Steenekam says, and to what the witnesses who were in the house are saying?
Manje kukhona yini owalethe incazelo yalo muntu owangena lapha ephethe isibhamu kodwa ehlukile kulaba abamchazayo lo muntu ngisho laba babesendlini?
Yes, my lord. So let's start here, my lord. I understood the question yesterday, or how Advocate Nisi asked me. It was the description insofar as suspect A, in terms of the dark color, the complexion. That's where the contention was. He referred specifically in terms of the dark color. And I've said in my recollection, one will have to go through all the statements. Now, having gone through the statements, my lord, the only people that I was able to pick up who refers to the dark complexion, it's Longwe, I think Zandi, I'll just have to check, my lord. But it's not all the witnesses who were inside the house. The other, I think it's about 3 of them that give the complexion of a dark person. In other words, the first intruder being dark, referring to the complexion. The others are simply giving description in terms of the dreadlocks and the height, and then that goes to the same, that becomes the same situation when they describe accused number 2. But not all of them are saying the person is dark. And when I'm saying all of them, my lord, I'm referring to their statements. That is why I said, as much as Warrant Officer Steenkamp prepared his statement in preparation of the identity kit, if you read what is contained in her summary in relation to what the people inside the house are saying, I've said it yesterday that there's no consistencies, because Kelly Khumalo, for example, the first person she interviewed, refers to a dark person refers to a revolver. You don't find it in a statement. If you go to other places where Zandi said she could not identify certain people, if you go, like Ms. Zandi Khumalo, the second witness, if you go to Zandi's statement, she says, I will be able to identify the intruders if I see them again. So you need to read this, my lord, with what actually the deponents have actually disposed. So yes, I was able to find statements where there is not dark color or complexion being mentioned of the first intruder.
Izolo ngizwisise kahle umbuzo futhi ke lo mbuzo ubuqonde ngokule ukhuluma ngebala la lo muntu okuthiwa wangena la kodwa ke uzofanele uma ufuna ukutholisisa kahle ufanele ufunde zonke izitatimende ngoba ngicabanga ukuthi bathatha kuphela la ehlanganisa khona uLongwe ethwala noZandi kodwa kubona bonke abathi lo owangena lapha wayenebala elinsundu abanye ke basebenzisa ke ama dreadlock nobude bomuntu and futhi abasho lutho ngebala lakhe kodwa uma usubheka lezi statement zalaba ke abebekhuluma ngebala elinsundu akukho ungaguquguquki lapho kwestatement kwalento abayishoyo ngoba abanye basho lokho abanye basho okunye ngoba uma sibheka lapha uKelly yebo uyakhuluma ukuthi yebo wayemnyama lo muntu and futhi ukhuluma nangevolovolo uZandi yena uthi wayezokwazi ukuthi mhlawumbe mangathola ithuba akwazi ukubakhomba labantu so kuzofanele ukuthi ubheke zonke izitatimende ukuze ngitholisise kahle ukuthi konje bathini.
My Lord, furthermore, the fifth witness that was interviewed by Ms. Warrant Officer Steenkamp, Advocate Nisi said obviously because this person was not inside the house, he didn't go into what this person says. But what is prevalent as well, and that is why you have to look, because that is how I conducted investigation. You don't look at an incident and isolate it, you investigate holistically. Tim Makaleni, my lord, gave a statement where he says he saw 3 intruders coming directly from Khumalo's house. Directly, and he says one of those intruders was carrying a firearm. The statement is in the docket. So then it becomes prudent, for him to identify, or rather to assist in the sketching of the identity kit. And I think that is why he assisted in identifying the person or one of the intruders, my lord. But he places himself in a position where he says he saw intruders coming directly from Khumalo's house, referred to that name, and one of them was armed with a firearm.
Manje uma uthi ufanele ubheke wonke amaphuzu owahlangana nawo ekuzameni ukuphenya ufanele ubheke konke awubheki into eyodwa kodwa ufanele ubheke konke ohlangana nawo ngoba siyazi ukuthi nanoma uthi Makaleni wayengekho endlini kodwa ke washo ukuthi yena wabona abantu abathathu bevela endlini bephuma endlini and washo ke nokuthi oyedwa wabo wayephethe isibhamu yikho ke kwakwazi ukuthi asize ukuthi kwenziwe loyamdwebo loya ukuthiwa identity kit.
And lastly, my lord, I've considered and agreed with Advocate Mnisi that not all the witnesses, where we differ, it's not to say all the witnesses describe the first intruder as dark. Where I've considered is that in terms of the description of the intruders, you have a bit of inconsistencies in terms of the description. There I concede, my lord. However, as I've said yesterday, the prominent and the main thing that you find in all the statements of the people who were inside the house is that they were intruders. The first intruder was shot, he was armed. The second one was told, there was a demand of cell phone and money. There was a struggle and a gunshot went off and the deceased was then shot. That is consistent, my lord. It's insofar as the description, finer details of the description of the accused. For example, my lord, it was also mentioned, without taking it further, that somewhere, perhaps let me not go there. I will want Advocate to lead me so that we don't step on each other's toes. Let me just leave it at that for now, my lord.
Okunye-ke siyazwana nobamnisi ukuthi yebo kukhona ungahambisani kobufakazi lana khona la ukwehluka ukukhona ngoba ke nanoma nje laba abanye bechazela ukuthi umuntu wayelapha wephethe isibhamu waye umuntu unebala elimnyama kodwa ke akusho ukuthi laba abanye nabo bachaza kanjalo into ke nje abayishoyo ukuthi ke lo muntu wayemfishane wayephethe isibhamu nokuthi wafika wacela amafoni nokuthi ke emva kokuthi kudutshulwe lapho ke base beyaphuma babali ikona nje kuphela.
Yes, my lord, that's my answer.
Thank you, Brigadier. You know, I said that I would not waste the course time by referring to what Mr. T. Makaleni is saying. Now that you're mentioning Mr. T. Makaleni in an endeavor to try and justify the theory that accused number 3 could have been the person that was in possession of the gun or of the firearm. This is what Makaleni is saying. According to Mrs. Steenkamp, she says, the fifth witness, Mr. T. Makaleni, residing at Mozamo 3942, compiled the suspect of B, compiled the face of suspect B. He saw 3 unknown African males in the vicinity of the gas station, busy on their cell phones. He saw them again at Kelly's mom's house. Suspect B stood at the gate. He gave the following description.
Manje kumhlolo wesihlanu uthi Makaleni nje usho ke kuka Steenkamp uthi ke lana uthi lona uhlala emzamo 3942 uthi wasinika incazelo ukuthi kunjani ubuso kaMsola uB uthi wabona amadoda amathathu abantu abansundu bese duze negarage babekhuluma ke nje noma khale ekhukhwini wabo and uthi waphinda wababona futhi ngasendlini kaMama kaKheli umsola ke uB wayeme ngasesangweni wasenika ke nathi incazelo yakhe.
African male, plus minus 25 years of age, plus minus 1.80 meters tall, slender build, medium brown complexion, clothing, black hooded top. Witness saw a golden insect in the upper teeth. Hairstyle, dreadlocks, facial hair. He had a mustache and a beard. He slave with a beard. Thank you.
Uthi ke lapho kwabona umuntu umAfrika wesilisa eneminyaka cishe ngaba 25 wathi ke ubude bakhe 1.8 meter and futhi ke lapho kuyabonakala ukuthi wayengakhuluphele wayenje futhi ke nebala lakhe lalingakhanyi kakhulu laliphakathi nje nendawo uthi wayegqoke ihudi emnyama and uthi wabona ke ukuthi unezinyo legolide ngenhla and futhi ke inwele zakhe kokwama dreadlocks and futhi ke wayenobu kusho ukuthi wayenamadevu futhi enentshebe.
He also had facial hair.
Futhi ke uyabona ukuthi wane nenwele ebusweni bakhe.
Now 1.8 meters tall. It's somebody that is just, I'm 1.8 meter, I'm 1.82 meters tall.
Mina ke ngina ubude bami 1.82 wamameter.
So plus minus that person could have been of my height.
Tikushuthi ke lo muntu wayecisha lingane nami.
But importantly, Mr. Makaleni described suspect B.
Manje kusemqoka lana ukuthi uMakaleni ukhuluma ngomsolwa uB.
Now these are two individuals
manje labantu la abantu ababili
that should be separated in terms of the intruders who got into the house.
abafanele bahlukaniswe njengabantu abahamba bayongena endlini.
Do you understand?
Sisi.
Yes, I fully understand and I agree with Advocate Mnisi, my lord. However, I think perhaps we didn't understand each other.
Okay.
So my endeavor, as Advocate Mnisi is putting it, it wasn't insofar as accused number 3, because I didn't say Makaleni identify accused 3. What I've said, I said the relevance, the endeavor that I was trying to put forward is that the assistance of Makaleni insofar as the compilation of the identikit, my lord, was necessary because in his statement, he says he saw 3 intruders coming out of Khumalo's house and one of them was identified, or rather he saw one of them carrying a firearm. I did not say that, and that's why I think there was a misunderstanding that him assisting in the identikit was the drafting or implicating accused 3. I simply said because of that contained in his statement, it was then necessary for him to assist in the drafting of the identikit. Hence, he assisted in the compilation of the second intruder. So I was making it a point that the fact that he was not one of the people who was inside the house, although he was outside, but he was able to see the intruders running out of the house and assist in the drafting of the identikit of suspect B, the second intruder. So they were in the same page, but it was not to say I'm saying accused 3 or he assisted in the drafting of the identikit for the first suspect. I think that's where the misunderstanding was. We are on the same page.
Ngakhona la besingazwani kahle ngoba umnisi ngoba mina bengizama ukusho ukuthi ke uMakaleni ubengakhulumi ngalomuntu umsola wesithathu futhi ke ukuthi usizo lwakhe beluvelaphi beliphuma nje ekutheni yena uthi wababona abantu abathathu bephuma endlini nokuthi khona oyedwa owayephethe isibhamu and yikho ke wakwazi ukuthi azosiza ekutheni kwenziwe lo yamdwebo le and ngoba yena wababona abantu abangena lapha hayi ukuthi ke wayezama ukuchaza ukuthi umsolo wesithathu wayenjani.
My lord, the court will also, just to support what I'm saying, that I'm not tip-and-toeing, is that the court will recall that when I was dealing with the very same exhibit with with Mr. Ramsipil, we dealt with this and I indicated that the correlation insofar as accused 2 is concerned, or collaboration, is that at that time in 2014 he was 25 years old. I was specific on this. The court will recall and the record will speak for itself. And I mentioned the issue of the black hoodie, which was then corroborated by Zungu, Constable Zungu, when he gave a statement that he saw accused 2 at a hostel at some stage wearing a black hoodie. So I'm saying this assertion by Makaleng was very clear that it relates to a suspect 2, not necessarily the first suspect.
Manje ikata lizokhumbula ukuthi ngesikhathi sikhuluma no Baba Ramsipili kwasilana sasikhuluma ngomsolo wesibili ukuthi umsolo ngaleso sikhathi wayeneminyaka ama25 and futhi ke uZungu iphoyisa la kwazi ukuthi limbone lapha hostel labona ukuthi wayenehoodie le emnyama ngoba uthi yena wambona ese hostel.
Yes, that's my answer.
Thank you, Brigadier. My lord, yesterday I dealt with some correspondence or certain letters that came from the Legal Practice Council. I was missing their exhibit numbers. Those letters that are referred to are in paragraph 154 of the list of exhibits. The first letter is exhibit YY, and the second letter was exhibit Y2. I think they relate to the confirmation of the enrollment of Advocate Mchiyako as an advocate with the LPC. But importantly, those were the exhibit numbers that I tend to refer to. There was also a charge sheet that contained another letter from Rustenburg that are also referred to. Thank you, madam. Thank you, Brigadier. Now,
Yes.
I again do not want to labor this point, Brigadier, but let me put it to you that in terms of the description of the person who had a gun when they got into the house of the Khumalos, the description by the occupants of the house of that intruder consistent. A dark-skinned person who had dreadlocks. That is the common denominator, if I were to borrow from your parlance. That is a common denominator. It's a golden thread that runs throughout their description of this suspect. A dark-skinned person who had dreadlocks. As I'm saying, that is what I'm putting it to you.
Manje malana ncazelo yalomuntu oyiphethe isibhamu lethwa yilaba ababesendlini ukuthi ke wayenebala elinsundu futhi wayenama dreadlocks and futhi ke lokho akuguquguquki bonke bayibeka kanjalo.
No, my lord, I disagree. Not all of them, and we can go through to the description. That's why I said I could pick up 3 of the people who were inside the house who relates to the dark skin, in terms of the first intruder. Not all of them. So it's not a general remark. That's why I indicated what is common in all the people that were in the house. Insofar as the intruders demanding cell phone and money, I've indicated those things. But insofar as the description, some of the witnesses that are that were inside the house at the time are describing the first intruder as dark, but the others are not giving the complexion of him. And the statements are here to confirm that.
Futhi ke angivumelani naloko ukuthi bonke basho njalo ngoba abathathu kuphela ababekhuluma ngebala elinsundu. So okusho ukuthi ke akuyona into efananayo kubo bonke le eshoyo into engathi ingafanana ile ndaba ye cellphone nokuthi bafuna imali ngoba abanye abazange balikhiphe nebala labantu.
Were the similarities, or my lord, or rather where an impression is created as if everyone in the house are saying the first intruder was dark, it is contained in Exhibit J that Advocate Mnisi was taking me. This is now Warrant Officer Steenkamp's statement, because he says they are almost like conquering each other. But if you go to the statements, because these witnesses or the people who were inside the house dispose affidavits, my lord, they are not saying that, my lord.
Futhi ke into kenza ukuthi kubukeke sengathi bakhuluma into eyodwa yilento etholakala lapha ngisho laba ababesendlini ilento ethola lapha ku exhibition J nalincazelo isithole lapha ku Warrant Officer Steenkamp. Kodwa ke uma siya statementini siyubona lo mehluko ukuthi umehluko ukhona kulabo ababekusho.
As a court, please, without interfering with Advocate Mnisi's cross-examination, he's referring to Exhibit J, and if one looks at the description given by Ms. Kelly Khumalo, the report mentions in the middle of the report, African male in his mid-20s, dark brown, shiny complexion. Now, the word brown has been omitted in putting the proposition to Brigadier Gininda. It's important to keep that description in mind. Dark brown, shiny complexion.
Is it please the court, my lord? Now, Brigadier, you constantly, let me just write this down. Now, you constantly has been mentioning throughout your testimony that Kelly Khumalo is the mastermind behind the death of the deceased, Senzo Meyiwa, not so?
Kaningi emfakazini bakho uveza ukuthi uKelly Khumalo uyena ophambili kulesahlakalo sokubulawa kamufi uSenzo Meyiwa.
Yes, my lord, based on the investigation, not my assumption. I mean, I think I made references to where her name comes from, you know, and that starts from accused one going up to, you know, and then obviously then the investigation that we conducted. So, but it starts from there, my lord, going up.
Yeah, but kuvela kuphenyo esalwenza akukona nje okuphuma engqondweni yami engizicabangela kona kodwa kuvela kuphenyo esalwenza yebo na kuloko kwalethwa umsolo wokuqala.
Thank you. Is this a narrative that is also shared, or that was also shared by the prosecutors who assisted you in this investigation?
Manje shothi lokhu umbono walethwa futhi nayilaba shushisi ababenisiza kuphenyo lweni.
I don't see the relevance of this question. There was a decision to prosecute the current accused before this court as to what view the prosecuting team held is irrelevant. So we have to focus on the accused that are before this court.
Does it please the court, my colleague should not be understanding me as not being concentrating on this case. The witness, my lord, has testified many a times that there were certain things that it did not do because it did not have specific instructions from the team of prosecutors who were assisting him in investigating this case. Consistently maintained that Kelly Khumalo is the kingpin in the assassination of the deceased in this case. I don't know, therefore, on what basis it is then alleged that the question that I'm asking him as to whether or not the team of prosecutors who assisted him shared the same view that Kelly Khumalo was a kingpin in this case. I don't know on what would then be the irrelevance of that question, my lord. Thank you, my lord. Did the team of prosecutors who assisted you in this case also share the same view? Were they part of that narrative that Kelly Khumalo is the kingpin?
Nje ke laba ke ababekusiza ekuphenyeni nabo babe nawo lo mqondo yini ukuthi uKelly Khumalo uyena wayephambili kulokho.
So my lord, I wouldn't say there was a narrative from the prosecutors. Evidence that was collected, my lord, at some stages I indicated was presented to the DPP, and further instructions insofar as Ms. Kelly Khumalo were given, up to the point where we read the statement that I made in November, my lord, and I indicated that there was no decision taken at that stage, you know, to bless the arrest of Ms. Kelly Khumalo. So there wasn't an objection. It was a question of further instructions and the adoption that the NPA was taking at the time, my lord.
Engingakusho ukuthi ke lokhu kwavela kubufaka kubuphenyi esasibenza and futhi ke sakudlulisela ku DPP kodwa ke njengoba bese ngichazile ukuthi kwakungena sasingekho isinqubo sokuthi ngaleso sikhathi akaboshwe uKelly Khumalo.
That's my answer, my lord.
I did not get really what my answer to the question, to my question is, because the question is very clear. Was the team of prosecutors or was it part of their narrative, their viewpoint that Kelly was the kingpin in the assassination of the deceased in this case? Irrespective of whether Kelly Khumalo was charged or not, did they hold that view in terms of your discussion? Remember, your discussion is not privileged. It's just not privileged, which is the reason why you were to come and tell this court that they gave me these instructions, they did not give me those instructions, I did this because of what they told me, they guided me here and there and there and there and there and there. Do you understand? Now,
I understand.
the question is, was it their narrative as well that Kelly was a kingpin? Thank you.
The witnesses answer that question. Must he repeat his answer? If so, what is the reason why he should repeat the answer that he's already given, my lord?
Maybe I did not get your answer, Brigadier, and there is nothing wrong in me requesting you to repeat your answer. There's definitely nothing wrong in requesting a witness to kindly repeat your answer.
Angizange ngiyizwe impendulo yakho sengiyacela ukuthi ngicela ungiphindele impendulo yakho.
My lord, the essence of my response was that there was no decision taken. Insofar as the sharing of the narrative, my understanding, and this is how I've been dealing with the NPA from time memorial, you conduct investigation as a police officer, you present the evidence to them. They decide as to whether to enroll the matter or not. And then if there is a need for further investigation, such will be communicated. And I've testified about this, my lord. So I'm not so sure if I can take it further than this insofar as what the advocates, because I can't get into their minds. What I know is what I presented to them and the responses that I've got, my lord.
Akuzange kube nesinqumo esathathwa ukuthi sonke sizobona kanje. Futhi ke mithina ke umsebenzi wethu ukuthi kwakuphenya sithole sikutholayo ebese sidlulisela kubona. Kube yibona ke abathatha isinqumo sokuthi lolu daba lolu bayadlulisela inkantolo. Uma ukuthi khona obulunye uphenyo abaludingayo, yebo sasikwazi ukuqhubeka kanjalo kodwa akukho kunye engachaza ukuya phambili ngalokho.
Thank you, Brigadier. Let us embark upon a standard 3 approach. Was it part of the prosecutors who were assisting you? Was it part of their narrative that accused number 1 is involved in the commission of this case?
I beg your pardon?
Relevance of a standard 3 approach. We submit, my lord, that the court has referred to the case of
yeah, I thought that case I gave you guys.
Azaf, and we
here's a
thought-
brigadier.
Yes.
It's being referred to as a standard 3.
Yes, and
You must approach him like a standard 3.
No, with due respect,
Okay,
that
I'm
is
not
what
going
I'm
to argue
saying.
that point. That's how I view it.
Yes, but my lord,
Let's resort to a standard 3 approach.
no, I am saying, let me take it step by step so that we understand each other. But I'm not saying that the brigadier is a standard 3, my lord. I would not have intended to say that. I am saying, let us simplify my question in the following sense. Brigadier, let me put it this way. Let me simplify my question. Let's not make meat out of the fact that, let us not make a mountain out of the ant small that are set, let us have a standard 3 approach. But what I intended to convey to you is that let us take it step by step. Maybe language is it's failing me. Thank you, Brigadier. But if you feel a little bit disrespected, my apology in that regard. Thank you, Brigadier.
Understood, my lord.
Thank you. Let us take it step by step. Now, was it part of the narrative of the team of prosecutors who assisted you that accused number 1 is complicit in this case?
Futhi ke kwaku umbono wobeshushisi bonke abanensizana nabo ukuthi umsola uqala naye ke wayethinteka kulolu daba.
My lord, at least number 1 has been charged. What is the relevance of that question?
I understand accused number one was charged, but was it part of their narrative that accused number one is complicit in this case? Yes or no?
Funa ukwazi ukuthi ke kwakuyindlela ababona ngayo yena ukuthi ke umsolwa uqala naye wayethinteka kulolu daba.
My Lord, perhaps to assist our answer this way.
Yes.
All the accused, 1 up to 5, when the memorandum was taken to the DPP,
Yes.
there was a decision to indict all of them on the charges, on the 5 charges that are before court, as per the indictment. That decision was taken. Insofar as Ms. Khumalo, further instructions were given for me to do. And that is why the statement I read here in court, where I was directed by Mr. Ramsipili, stated the date of November 2014. It was part of those further instructions to say, follow these instructions and then bring it back. And then subsequent to that, then the warrant was not signed. But there was never an objection to say we should not pursue this. I don't know if it will assist, but I will not be able to quote word for word as we're sitting there what the advocates were saying. But there was a desire to say, let us get more evidence to connect. Hence I said, my Lord, before this accused appeared in October, we had some evidence against Ms. Khumalo, which I've explained in this court. Later in November, we had more. We even dealt with the cell phone numbers. That was part of the prosecutorial driven investigation. So there was a working together between myself and the prosecution. But insofar as the ultimate decision to prosecute, my Lord, that lies in the hands of the NPA. And I think it will be dangerous for me to venture into that area as to what informed them. But there was a working together in terms of what should be done with regard to the evidence or the pointers that implicate Ms. Khumalo.
Thank you.
Isinqumo esaphuma sokuthi ke umsolo oqala ukuyofika kwesihlanu bangathweswa amacala, kodwa ke akuzange kuphume incwadi ephuma kwa DNA echaza ukuthi ke kufanele kusetshenzwe kanje, kodwa ke kwaphuma ke enye ke instruction evela eyalethwa kumina mayelana no Khumalo. Kodwa ke into eyikhona nje ukuthi sasifanele siqhubekele phambili senze umsebenzi wethu, and ke isinqumo ke esavela ko prosecutor esasivela ku NPA, and thina sasebenzisana nokuthi sizama ukuthi sithole ubufakazi obungasiza ukuthi sizwisise kahle indaba kaKhumalo.
Yes, my Lord.
I'm still struggling to get my answer on whether or not the fact that Khumalo is a kingpin in the matter of Senzo Meyiwa was part of the narrative that the team of prosecutors, actually let me not say the team of prosecutors, but the office of the DPP Pretoria had when they decided on this matter. I haven't received my answer. And I don't know what is the difficulty in saying, yeah, no, DPP Pretoria was of the view that Kelly was a kingpin in this case. However, she could not be charged because of this and this and this. That would have sounded better. But to simply decide not to answer my question, clouding it with a whole lot of lengthy explanation, I really don't think that assists the court. But nonetheless, I realize that there's an objection from my colleague.
As a court, please, my Lord, and we don't want to belabor this point. The witness is clear that the discretion to charge lies with the Director of Public Prosecution. He presented a memo, and this is the decision was taken by the Director of Public Prosecutions. He cannot take it any further. He said, he cannot, as he put it, go into the minds of, the Office of the Director of Public Prosecutions. I think my learned friend will unfortunately have to live with that answer.
And unfortunately, I am not prepared to live with that answer. But I do realize that it's a very difficult one. But nonetheless, let me proceed. The reason why I am asking this, it's because in terms of the law, when a person gets indicted at the High Court, in terms of Section 144 of the Criminal Procedure Act, the state must inform the court the facts upon which they are basing their allegations against those that they've indicted before court. That is law, which is the reason why I am asking you that question. Do you understand?
Usho ukuthi isizathu ke ukuthi ngibuze kanje ukuthi ke ngaphansi ka section 104 umthetho ubugebengu ukuthi ke umshushisi ufanele ayitshele inkantolo ukuthi yini indaba befuna ukuthi bathwese umuntu amacala futhi basebenzise ziphi izathu.
My Lord, I understand. However, and I go back again, my part as an investigating officer, and exactly that, my Lord, was done, and the matter, it's a question of separation of powers, and I've explained this, my Lord. The docket was taken to the DPP, as is normally done, for a decision. A decision was taken. Now, for me, my Lord, it's not a difficulty, but I can't speak on behalf of the NPA. It's separated, my Lord. I did my part. I produced the evidence that we had insofar as this accused and what pointed to Ms. Kelly Khumalo. It's a normal, that's how it's done, my Lord. You present it to the NPA, then they will communicate their decision to you as they've done in this instance. Now, I'm not sure, my Lord, how do I then speak on behalf of them? I think the NPA in this situation, my Lord, are better vested with the knowledge of giving Ms. Advocate Mnisi the answers that is seek, because I can't speak on their behalf, my Lord.
Mina ke into indlela engizwisisa ngayo ukuthi umsebenzi wethu ukuthi njenge umuntu ophenyayo siyaphenya thina and mase siqedile ngale sithatha le docket sidisa kwa DPP uyena uzothatha isinqumo sokuthi uqhubeka kanjani. Angikwazi ukubakhulumela abaka NPA ngoba thina owethu umsebenzi phela ukuphenya mase siphenyile bese sidlulisela kwa DPP ibona abathatha isinqumo and futhi angikwazi ukuthi ngibakhulumele ibona abangasikhulumela ukuthi indaba ethatha isinqumo esinje.
Same with the section or the law that Advocate Mnisi referred me to. I'm not sure, my Lord, how best can I assist him there. I mean, that lies between him and I think the court and with greatest respect, the Advocate Baloyi, because what do I say, my Lord? That's not my terrain as well.
Futhi ke nangumthetho ayikuyafana nalapha akukho mina engakwazi ukusho ngoba akuyona into engathi ngifanele ngingenelele leyo angayikhuluma mhlambe ke no Advocate Baloyi kodwa mina ngikwazi ukuyingena leyo ngoba akuyona indawo engisenzela kuyona.
Yes, my Lord.
Now, you're mentioning that you investigated the docket, you gathered all the evidence and presented it to the state. Now, was it part of your, before I get to there, and then after submitting that document, then the state went on to make a decision to charge the 5 accused persons that are before court here, and they gave you instructions to go and issue out warrants of arrest against them, not so?
Manje ke emva ukuthi ke uze uphemo wakho uphenyo lwakho wathatha ke le case wayisa ke ku bashushisi bayibheka ke base bethatha isinqumo sokuthi ke baqhubeka nokuthi babathwese icala, and emva kwaloko ke istate ke sasisibuya ke sithi sebengashashwa bangakhishwa ke nama warrant ukuthi bangaboshwa labantu kunjani.
My Lord, the first part is correct. A decision was taken and then an indictment was sent to me. I'm not sure if there was instructions to say go and get warrant of arrest. I mean, as I've said before, my Lord, J50s are a way of bringing the accused persons before court because the decision was already taken that, they're indicted for these charges. I then took that route, my Lord, of applying for J50s as per the affidavit that I disposed, and then that was solely granted, my Lord, and then the accused were brought before court.
kuyiko kodwa ke okwesibili akunjani ngoba zange kube nama-warrant of arrest noma incwadi zokubopha ezakhe thina ke esacela nje ukuthi sicela ama-J50 ngoba iwona esawasenzisa ukuthi abantu abalethwe enkantolo njengoba ngishilo kwa-affidavit yami.
Thank you, Brigadier. Further, that part of the instructions in that indictment was that they should be arraigned for trial in the High Court.
Futhi ke kuyisa phambili lokho ukuthi kwathiwa abayiswe abahambe ke beyovela enkantolo ephakeme.
I suppose, my lord, I'm just not sure word for word now because I'll have to go through to the indictment, my lord. But I suppose if Advocate Mnisi saw it recently, I will not dispute that.
Ngiphikiseke lokho uma ukuthi u-Advocate Mnisi akudala ekubonile anginaso isiqiniseko sokuthi kunjalo kodwa ngifake ngibheke.
Yes, that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Khumalo is also complicit in the murder of Senzo Meyiwa?
Manje musuzofaka lezi ncwadi zakho kwa-DPP wakufaka yini nokuthi lo Kelly Khumalo uyathinteka kuleli cala?
My lord, yes, I presented all the evidence as it is, and as I indicated, part of my recommendation or request was that she should be charged, but then there were further instructions insofar as she is concerned at that stage, my lord.
Yebo ngafaka konke kulezi ncwadi engazifaka kwa-DPP and futhi ngasho ke nokuthi naye ufanele athoswe icala.
And based on your investigation, you were satisfied that there were reasonable grounds to believe that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the murder of the deceased.
Ngithi wena ke wawenelisekile ngokuthi ke uyasoleka naye and futhi ke wawukholwa ukuthi kufanele naye athoswe icala.
Yes, I was, my lord.
Thank you.
Yebo kunjani.
Now, this is what the state told this court in terms of Section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. And I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial fact which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
Yes, it is the court, my lord. I think that is, it's a misdirection, it's a misrepresentation of fact. It can be had to be said that an information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case in my line of cross-examination? I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case, then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid, I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case, my lord. Definitely.
Yes, Mr.
Well, I don't know what daring and the guilt refers to,
Maybe
but
let's read section 104.
yes. But such obnoxious comment notwithstanding, my lord, we submit that this witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. And we don't want to repeat ourselves, my lord, but we submit that that line of cross-examination should be disallowed. Did the court say I must read our section
so that's it.
144?
People understand what we are about. Because we're quoting sections which maybe some people are not even aware what they say. I mean,
the heading to section 144 is charged in superior court to be laid in an indictment. It's a very long section. I'll read the whole of it. Subsection 1. Where an Attorney General, now the Director of Public Prosecutions, arraigns an accused for sentence or trial by a superior court, the charge shall be contained in a document called an indictment, which shall be framed in the name of the Attorney General. Subsection 2. The indictment shall, in addition to the charge against the accused, include the name and, where known and where applicable, the address and a description of the accused with regard to sex, nationality, and age. Subsection 3A, where an Attorney General under Section 75, 1213B or 1222 Roman figure 1 arraigns an accused for a summary trial in a superior court, the indictment shall be accompanied by a summary of substantial facts of the case. That is what we are currently debating. A summary of substantial facts of the case that, in the opinion of the Attorney General, are necessary to inform the accused of the allegations against him, and that will not be prejudicial to the administration of justice or the security of the state, as well as a list of the names and addresses of the witnesses the Attorney General intends calling at the summary trial on behalf of the state, provided that, Roman figure 1, this provision shall not be construed that the state shall be bound by the content of the summary. This is the point that we've just made. Roman figure 2, the Attorney General may withhold the names and address of a witness if he is of the opinion that such witness may be tampered with or be intimidated, or that it will be in the interest of the security of the state that the name and address of such witness be withheld. Roman figure 3, The omission of the name or address of a witness from such list shall in no way affect the validity of the trial. In this matter, there were certain names that were omitted. Roman figure 3B, where the evidence for the state at the trial of the accused differs in a material respect from the summary referred to in paragraph A, the trial court may, at the request of the accused, and if it appears to the court that the accused might be prejudiced in his defense by reason of such difference, adjourn the trial for such period as the court may seem adequate. Subsection 4, Roman figure 1, an indictment together with a notice of trial referred to in the rules of court shall, unless an accused agrees to a shorter period, be served on an accused at least 10 days, Sundays and public holidays excluded, before the date appointed for the trial, the Roman figure 1, in accordance with the procedure and manner laid down by the rules of court, by handing it to him personally, or if he cannot be found, by delivering it at his place of residence or place of employment or business to a person apparently over the age of 16 years and apparently residing or employed there, or if he has been released on bail, by leaving it at the place determined under section 62 for the service of any document on him, or Roman figure 2, by the magistrate or regional magistrate committing him to the superior court by handing it to him. Then subsection 4B, a return of the mode of service by the person who served the indictment and the notice of trial, or if the said documents were served in court on the accused by a magistrate or regional magistrate, an endorsement to that effect on the record of the proceedings, may, upon the failure of the accused to attend the proceedings in a superior court, be handed in at the proceedings and shall be prima facie proof of the service. Then lastly, subsection 4C, the provisions of section 55, 1 and 2 shall mutatis mutandis apply with reference to a notice of trial served on an accused in terms of this section. So, my Lord, this simply buttresses the point that was made by the state earlier on, that the DPP, in his opinion, has set out a summary of substantial facts, and this witness can be of no assistance as far as that is concerned.
Yes, let's hear you, Mr. Minister.
As it is the court, madam. May I respond?
Hello?
I'm saying, may I respond?
No, you must address me on the law, because you
That
say...
is what I'm saying, madam.
Also, you're saying?
I'm saying, may I respond?
Yes.
Yes. I think my colleague is running away from telling the court about what you read being a prejudice.
What?
Prejudice to the accused. These accused persons, my lords, have been arraigned to this court to answer the allegations that are contained in the summary of the substantial fact. And there is nowhere in the summary of the substantial fact where Kelly Khumalo is mentioned as a kingpin. Instead, in the summary of the substantial fact, Kelly is mentioned as a victim. Now, all along, throughout the testimony of Brigadier Gininda, Kelly Khumalo is branded as the kingpin, the person who organized the killing of the deceased, which is the reason why I am asking if at the very inception, at the drawing, at the preparation of the summary of the substantial facts, the state was aware that Kelly was a kingpin. so that when it decided to draw this summary of substantial fact, that should have been a factor to be taken into account, so that when these accused persons come and answer on the allegations that are against them, they know that amongst others, we are before this court to answer allegations that we were in consort. We worked together with Kelly Khumalo to assassinate Senzo Meyiwa, and that is not there. They are now expected to answer on something that was initially not put to them at the beginning of the trial. Remember, my lord, when the charge is being put against this accused person, the summary of the substantial fact is also read into the record. That is part of the charge sheet. There is nowhere where they were called upon to come and answer that they worked together with Kelly Khumalo. That is the reason why I am basically asking, and I'm not trying to indict any person. I'm getting somewhere with this line of cross-examination as to whether or not at the preparation of this indictment was the state aware that Kelly Khumalo, without Kelly Khumalo, would not have been here basically. As per the testimony of Brigadier Gininda, we would not have been here because accused persons would not have had anyone to come. According to the allegations of Brigadier Gininda, these accused persons would not have had anyone to entice them to go and kill Senzo Meyiwa. But that is not contained in the summary of substantial fact. It doesn't matter, my lord, whether a person is charged or not charged, but the summary of substantial fact must contain the information that is contained in the case docket, so that when the accused persons are confronted with that allegation, they are able to respond accordingly. And that has not happened in this case, which is the reason why I am compelled to find out, because now they are expected in the middle of the trial to answer to something that has not been there at the inception of the trial. There's nothing wrong in me finding out whether or not at the time at which the decision was made, the state was already aware that Kelly Khumalo was a kingpin.
But you're arguing something different.
No, okay, my lord, let me hear. When the court says it's different, in what way, my lord?
No, let's play your question first, because you're into the merits, etc.
No, I'm responding to the state, my lord.
What were you responding about the irrelevance of this witness being cross-examined on the content
Yes,
of the indictment,
yes.
which, according to you, you're saying it's not
Yes.
relevant for this witness because it is the
Yes.
Director of Public Prosecution
Who
drafts
decides? Yes,
the indictment, including even that panoply of facts.
yes.
And that you also say that even that also doesn't bind the state.
Yes.
I thought that was what we were talking about.
Yes.
Now we're talking about Kelly Khumalo.
No, my lord. The Director of Public Prosecution, yes, does draft an indictment, but he's drafting an indictment based on what facts?
No, fine.
Who brings the facts to them?
Mr.
Yes.
You can argue those facts. But if you read that act,
Yes.
it says in
The section.
It
Yes.
says in the opinion of the Director of Public Prosecution,
Yes.
not this witness.
That is correct, my lord. But now, if it is in the opinion of the Director of Public Prosecution and
Yes.
the witness includes something which, in the opinion of the Director of Public Prosecution, has not been included here, must we then fold our arms and say no, because the Director of Public Prosecution has decided not to include this, we should also not take this witness on
Then
that evidence?
Then you should have requested further particulars.
My lord, we did
No,
not.
no, that's the procedure.
Yes.
Am I correct, sir?
Yes.
Otherwise, we'll be here the whole day.
In
When you are hit with, your client is served with an indictment,
Yes.
you've got a right to request further particulars and further and better particulars. Did you do that, sir?
Let me respond, my lord.
Yeah.
Yes.
Yeah, fine.
There is no way where in the indictment it is mentioned that Kelly Khumalo is a kingpin. Had that been mentioned from the onset, we'll definitely have requested further particulars. There is nowhere in the indictment where it is mentioned that Kelly Khumalo is a suspect. Instead, in the indictment, it is specifically mentioned that Kelly Khumalo is a witness. How could we then have been enabled to request further particulars when we did not know that Kelly Khumalo, in the mind of the investigating officer, Kelly Khumalo is a kingpin.
But Kelly
This-
Khumalo, sorry.
Yes.
Kelly Khumalo is not charged in this court. I don't see her.
Yes, she is not charged, my
Yeah,
lord. But
so
the fact
why should I respond to that? I only respond to persons who are charged.
that is correct.
Whereas litis contestatio
Yes,
between the accused and the state.
Yes,
Kelly Khumalo, I don't know.
Yes, my lord. Her not having been charged, my lord,
Yeah, you can argue that.
it's not a, it's not
Okay,
a, it's not a.
ask that very question
I-
to this witness. Every question you want to ask him, ask him.
My lord,
May I request a short adjournment, my lord? It's already tea time. I think it's already 11:15. May I request a short adjournment? In any event, I also need to respond to the call of nature as well, my lord. I come and pursue this point when I come back. Thank you, my lord.
Yes,
my
sir.
lord, my lord, before we adjourn,
I'm
with due respect, my lord, for the sake of...
nature, you know, it's killing me.
Okay, 15 minutes.
from the court, my lord.
Oh,
Yes.
I
My
thought
lord,
you were-
it's in respect of the provisions of section 144,
Yeah,
which has just been read here
Yeah,
in court. And the reason why I'm standing up, my lord, I will just read subsection 3 only
Yeah,
of
right.
section 144, which says when Attorney General under section 75, 121 subsection 3B or 122 subsection 2(1) arraigns an accused for a summary trial in a superior court. The indictment shall be accompanied by a summary of substantial facts
yes,
of the case that in the opinion of the Attorney General are necessary to inform the accused of the allegations against him.
yes.
So, my lord, my submission is that if the indictment, inclusive of the substantial facts, have been served and read into the record.
Let's keep one thing clear.
Yes, ma'am.
That summary of facts doesn't bind the state. You can't. Am I right, sir?
Yes, indeed, that's what we've placed on.
Yeah, that's what's
on
critical,
record.
because we're reading evidence now. We're including evidence in our argument.
Can I
The
finish? ma'am?
charge sheet just says you are charged with murder in that on such and such a day you killed Ratamukotli. Fine.
My lord,
Okay, go
Can
on.
I finish?
Yeah,
ma'am?
finish.
Thank you. And it says, allegations against him and that which are necessary against him and that will not be prejudicial to the administration of justice,
Yes. Fine, no problem.
or a security of state, as well as list of the witnesses, addresses of the witnesses, and the general and the Attorney General intends calling at the summary of the trial on
Right.
behalf of the state.
Yeah.
My lord, my submission is that as much as the summary of facts and the indictment, it's not binding to the state,
Right.
but it forms part, the substantial facts forms part of the record because they are read into the record. And the purpose of the substantial facts to be read into the record is to inform the accused of the allegations against him or her.
Yeah. Yeah.
Then my submission, my lord, is that then if on the list of the substantial facts, there is a fact in which the
It's a fact or an allegation.
it's an allegation, my lord.
Yes,
Can I
you see.
just rephrase it?
Yeah.
Yes. There's an
That's it,
allegation.
yeah.
Specifically, wherein it refers to Ms. Kelly Khumalo as a complainant.
Is she a complainant?
My lord, I'm saying as is referred to here in paragraph 5, my lord. My lord, then my submission is that the defense should be allowed to seek clarity to the witness on the issues that appears or on the facts that appears on the substantial facts, my lord.
Okay, fine.
Can we maybe just have
Yeah.
another bite at the cherry? If my colleague is done.
Yeah, it's through. She's through.
Okay. My lord, we just want to raise a point of procedure. My colleagues are at liberty to raise any point, to argue any point. Section 85 was at their disposal to object against the charge sheet. Section 106 was also at their disposal.
Yeah.
Now we're busy with cross-examination, and now legal arguments have been raised in cross-examination. My suggestion, if they have any legal points to raise, they're at liberty to do so, to ask for an adjournment, to formulate such legal arguments. But at this stage, my lord, we submit that we are busy with cross-examination, and we should then focus on the cross-examination. If anyone wants to raise legal points, they may do so, file heads of argument, on which, we'll all respond. That is the
Yeah,
state's
fine.
suggestion.
You know what? I don't want to be accused of being unfair, even if I understand the law differently. from what is being argued here about the merits. I'm here to decide on the merits. The arguments, I've got to listen to them, fine. The evidence, I've got to listen to it and also thereafter decide whether the state has proven its case beyond a reasonable doubt. But you know what? You can ask this witness anything you want. Mr. Miss, anything you want. Anything.
No, my lord.
I'm talking like you. When you were proposing that there's nothing which you have touched which does not concern the case. So
Yes.
you can ask anything you want about the case. Okay, fine. That's my ruling.
As it is the
Yeah,
court, my
fine.
lord. But again,
No, I've just ruled. Otherwise, we'll be here the whole day.
yes, my lord, but I'm saying I also have to be informed by the fact that whatever I'm asking this witness, even if it is part of the case, it must be relevant.
No.
Yes.
You can ask anything you want of this witness, please. Because
Thank-
when we come to relevancy,
Yes.
then you may have problems, like your learned colleague is saying. He's saying what you're asking is irrelevant because it is the Director of Public Prosecution who formulated that document and took a decision to charge the 5 gentlemen in front of us.
Yes, my lord.
So please, just go on there.
But I think that objection loses sight of the fact that it is very same witness who introduced the notion that this case is prosecutor driven by the Office of the Director of Public Prosecution, my lord. But nonetheless, I realize, Brigadier, thank you. I realize that apparently I'll not be in a position to get the answer to whether or not the Office of the Director of Public Prosecution was privy to the fact that Kelly is a kingpin when they decided to take a decision in this case. That I'm comfortable with. But nonetheless, let us proceed. Now, in terms of your testimony, you are mentioning that he is just a recouping, that Kelly is a kingpin, not so.
Ufazini bakho uthi uKelly uyena ohamba phambili ukwenzeni ukudaleni leli cala.
Yes, the evidence, my lord, that we collected suggests that she's a trigger point.
Yebo ufazi simtholile ibona benza sibone ukuthi konke kusukela kuyena.
Now, in terms of your investigation, could you find any motive why Kelly would have wanted to kill Senzo?
La ekuphengeni kwakho wathola yena ukuthi ngabe kuyisiphi isizathu sokuthi afune ukubulala uSenzo uKelly?
No, my lord, we looked at a number of things. I mean, that is why the court will recall we even read the messages between her and the sister. But to say we found one specific motive, my lord, we've not got that. We are not there yet, my lord. We are still investigating anyway.
Sisaqhubeka nokuphenya angeke ngisho ukuthi ke kukhona isizathu esisodwa singathi isona anaso kodwa ke ziningi izinto esizibhekile sibheke saphinda futhi sabheka nemlayezo eyayithunyelwa phakathi kwakhe nodadewabo kodwa ke angeke ngoba saqhubeka nophenyo asikafinyeleli kulo.
Thank you, sir. What is prompting all this question is because as I listen to the evidence of the people who were in the house, Madlala, Longetwala, Zandile Twala, Zandile Khumalo, yes, I'm sorry, Zandile Khumalo, basically those are the 3 people who testified were in the house. They said, upon Senzo being, and I'm not here to plead Kelly's case, but they said, upon Senzo being shot at, Kelly was very hysterical. She assisted in loading the deceased into the vehicle and she drove like nobody's business. She drove like mad trying to rush the deceased to the hospital. And then something says to me, okay, but then you can interpret Mr.
Manje ke lokhu okushiwa umadlala nolongo ethwala noSizande Khumalo kuthiwa ke uKheli wayekhala kakhulu ngesikhathi ke eselinyaziwe uSenzo kuthiwa wasiza ngokuthi asize nokuthi uSenzo afakwe emotweni futhi ke washayela ngesivinini esikhulu.
Now, and at the hospital there, she defied procedures with a view to try that Senzo should be assisted as quick as possible.
Futhi nasesibhedlela ke wafike wacela ukuthi asizwe ngokusheshsha.
Now, something comes to me and say, but the investigating officer keeps on telling this court that, look, Kelly is a trigger point. But what could have been the motive for her to kill Senzo? And again, immediately after Senzo was shot by the bullet, okay?
Futhi ke njoba ke ngizwa lana ukuthi ke umseshi uthi yena uKheli uyena obehamba phambili kubulaweni ngaSenzo. Kodwa ke isizathu ngisitholisisa ukuthi kungabe kuyini isizathu sokuthi afune ukumbulala.
And again, after having been hit or struck by the bullet, Kelly did not waste any time. You know, they bundled the deceased into the motor vehicle and drove at a high speed. That is according to Long. Drove at a high speed to the hospital. Is that conduct really compatible with the conduct of a person who wanted another person being killed?
Futhi ke emva kokuthi adutshulweke ngokusho kaLongo ethwala uKheli wazama ukuthi Senzo Meyiwa afakwe ngokusheshsha emotweni waseshayela ngesikhulu isivini lokho izenzo zomuntu obefisa ukuthi abulawe.
Now do you understand why I wanted to know whether it was the state's narrative from the inception of this case that Kelly Khumalo was the kingpin? Do you now understand?
Manje sizisa ukuthi yini ngithi ke mina bengifuna ukuzwisisa kahle ukuthi yini state uKheli Khumalo uyena ohamba phambili ekuzameni ukuthi ekwenzeni lethal.
So, my lord, I'll start with the last question. As I've said, I cannot speak on behalf of the NPA. I've said it. Decision lies with them insofar as the prosecution, and I can't really, even if I want, I'll be venturing into a terrain where I've got no authority, so I can't take it further than that.
Yes.
Docket was forwarded with all the evidence, including Ms. Kelly Khumalo, and I've indicated that no decision insofar as her position is taken was taken, my lord.
Uqala ngasho ngithi mina angeke ngikwazi ukukhulumela iNPA idocket yadluliswa iswa kubona efaka futhi noKheli Khumalo kodwa ngeke ngikwazi ukubakhulumela abeNPA.
I mean, her position is concerned, my lord. So now, with regard to the naming of Ms. Kelly Khumalo as the kingpin, my lord, the evidence, it is not my assertion. It is not me who stood up and said, now we're going to pursue Ms. Kelly Khumalo. I've indicated way back, my lord, that initially when we started this investigation, it looked like it was a robbery gone wrong. After, obviously, we dissected the docket and concluded that they were intruders. The evidence that was before us at the time when I started the investigation, it looked as if they were intruders, and during the robbery, who were intending to rob, and then things went wrong and the deceased was shot. That's what the evidence was pointing at the time. Fast-tracking forward, my lord, getting to accused number 1 and subsequent accused number 2, the picture changed, where for the first time the name of Ms. Kelly Khumalo came in as a trigger point. Now, when you investigate, you can't ignore that fact. That is where now the investigation, insofar as Ms. Kelly Khumalo comes in, then the exhibit JJ and HH with regard to accused 2 kicks in, and then the name again is mentioned of Ms. Kelly Khumalo as trigger point. Then the investigation goes further and further and further, and all manner of things that I spoke about, my lord, in terms of the links, the cell phone, which I said it could not be. As I was investigating, remember now this allegation is being made. Now I'm trying to find collaboration to say, could this be true or false? And if we found that it was not supported, my lord, yes, we're going to make a finding that this is not true. But then the investigation then revealed, in terms of the experts that we brought in, insofar as, for example, cell phone analysis, that says I can establish the link between accused 5 and Ms. Kelly Khumalo with regards to those 2 calls. We've dealt with that. Then he comes in and says, but I can also find the see-through bag between accused 3, the see-through bag that is a common link between accused 3, Ms. Kelly Khumalo in specific because I'm talking to her, and the other links that I'm talking about, my lord. Now, if you take that collectively, and I've also touched base on the issues of the cell phones, which at the time of the offense were not disclosed to the police at the time, because we're now trying to find collaboration, whether there is substance in what was suggested in the confessions. You find all these facts, my lord. You cannot now ignore those things and say, no, it's not true. Evidence that was collected, not my thinking, evidence that was collected supported that there was a trigger point from Ms. Kelly Khumalo, and that's what the evidence said, my lord, emanating from the confessions of both accused number 1 and accused number 2, because that is where the name of Ms. Kelly Khumalo started, not before that.
Engakusho ke manje ukuthi ke ukuze sifinyelele lapho esathi khona u Kelly Khumalo uyathindeka akuyona into esho yimina kodwa ke ekuqaleni kokuzwa ukuthi kukhona ubugebengu obenziwa lapha ngoba khona babezama ukungena bayobamba inkunzi nokuthi kwakukhona abantu abakhona eqaleni thina sasibona sengathi yebo kwakubanjwa inkunzi nokuthi kwakukhona ke ababangenela lapho nokuthi ke khona uwadutshula lapho sacabanga ukuthi wadutshula ngoba kuwukuthi ngesikhathi bezama ukubamba inkunzi khona ungahambanga kahle, kodwa ke uma sesiqhubekela phambili sesithatha nomfazi womsolo oqala nowesibili sesiqhubekela phambili necala kuyabonakala kuyavela ukuthi hayibo uKelly ngathi naye uyathinteka khona lapho, and mase sifaka futhi nembukiso uJJ no HH kuyabonakala ukuthi cha uKelly ngempela ingathi khona ukusola ukuthi ngabe kuyena ohamba phambili kuleli cala na ukwabe kungelona iqiniso bengeke kube inkinga ukuthi sisheshe sibone nakhona ukuthi hayi lona impela akukho lutho olumhlanganisa naleli cala, kodwa ke ekuqhubekeni nokuthi sifune ukuthi sifunisise siye phambili siphenye kwaqala ukubona izinto ezinjengesikhwama lesi esatholakala isiphoma leso okwazi ukubona ngaphakathi kwaso esasibonakala usatholakala efonini kaKelly nasefonini kaMsolo wesithathu kona kwazi uqala ukusenza ukuthi siqala ukubona ukuthi cha khona izinto engathi ziyaxhumana la, and ngeke sikwazi ukuziba ukuthi siyabona ukuthi khona izinto ezibonakalayo la ukuthi hayi uKelly ngathi uyathinteka, and okukhulu nje okwasinika ukuthi sibe nalowo mqondo ukuthi yiloko kwavela ekakhulukazi emafonini kumakhalekhukhwini.
Yes, my lord, I just want to put this into correct context. When I said this is where the name Kelly Khumalo came up, I meant to say when her name was now labeled as a mastermind. That's the right context I want to put it.
No, engifuna ukuchaza ukuthi lavela kanjani la ebengizama ukuchaza ukuthi lavela kanjani ilona igama lakhe njengowayo ingqawo phambili kulokhu ekuzameni ukulungisa ukuthi ayodutshula usenzo.
So in essence, my lord, what I'm saying, you cannot now, as much as I hear what Advocate Miss is saying in how it was described, Ms. Kelly Khumalo acted after the incident up to when the deceased was taken to the hospital and whatever transpired at the hospital. After this allegation then came up in the confessions, investigations were done, and this investigation, my lord, revealed what I've tabled before court. And in the search for the truth, I could not, as I'm standing here, I could not find a reasonable explanation or justification as to why, for example, and I'll deal with the calls, what was the relationship between Ms. Kelly Khumalo and accused 5? And what was those calls were about in terms of relations? Because remember, she was a public performer, a singer. It could have been that, for example, they are related, or there was some transactions of some business that they were doing together. I could not find the legitimate reasons for that transaction. I could not, up to today standing here. I could not find reasons as to why there were these similarities in terms of the picture of the money appearing in the in the photo downloads of accused 3, as well as the one of Ms. Kelly Khumalo, and to be fair, the one of Longo as well. I could not find reason, my lord, as to why the 4 numbers that were picked up by the expert to say they were existing on that day, because I've explained, my lord, that the issue of the numbers came in when I wanted to establish, because when you follow the confession, it is said one of the accused were constantly talking to Ms. Kelly Khumalo or referring to her as sisters. And I've indicated that, my lord, that when you were looking at the numbers that were known to the state, these 2 numbers, the one that was alleged to have been robbed, which was robbed and was picked up by Muleleke section, and the one that remained, which was downloaded, we could not find those linkages. We could not find calls that would have come from these accused, except the calls of the 2 of August and the 15th of October on her number that came from accused 5. But the calls of that specific day, on the day of the incident, we could not find. And that then widened the investigation, which then revealed that there were numbers that she was using on that day. And unfortunately, because the police were not aware at the time, could not get those numbers, and that link could not be established, my lord. When we came to know about them, the window period, as I've said, my lord, had passed, and we could not get the actual handset to actually do the download. Now, if you take these facts that I've just mentioned, my lord, or these that were revealed by the investigation, you cannot ignore the fact that there is something untoward, and that is why I then made the application for the J50 in terms of section 43 for Ms. Kelly Khumalo to be added as one of the accused, my lord.
Yebo, ngikuzwile ukube kukhulunywa ubaba umnisi ukuthi ke uKelly Khumalo waziphatha kanjani ngesikhathi uSenzo Meyiwa esibhedlela. Ngiyakuzwa lokho. Kodwa ke khona into engesakwazi ukuyiziba ubufakazi esihlangana nabo. Mina vele bengakwazi ukuthi ngithi ngingayithola ukuhlobana kukaKelly nomsola wesihlanu, ngoba mhlambe ke asazi mhlambe babe yihlobo o mhlambe babazana ngebhizinisi. Kufika namhlanje angakwazi ukuthi ngitholisise lokho. Kodwa ke ukuthi kwakukhona isithombe esifana nayo esisefonini kaLongo ethwala umsola wesithathu noKelly, asingeke sikuzibe lokho. Futhi ke nokuthi ke umsola wesithubili waletha i-confession and nokuthi ke futhi ke la eqoqeni abasola babebiza uKelly Khumalo ukuthi sisters. Ngiyabona ngathi khona ukuthi ngathi bayamazi, kodwa akazange sithole mhlambe ke amafoni aye ababeqhubana ngawo, kodwa kwaba khona amabili nje, umhla 2 August nomhla 15 October. And lapho ke ekhuluma khona nomsola wesihlanu, kodwa ngokubona ke kunjalo sabona ukuthi kungcono senabise uphenyo lwethu sizama ukutholisisa ukuthi ngaba kunani futhi olunye lungasisiza. Kodwa ke inamba ezazikhona sasingakwazi ukuthi singasenzisa ngoba sasingenabo umakhala ekhukhwini la bese singakwazi ukuthi singenza ama download bona ukuthi sithole ulwazi olungasisiza ukuthi siqhubekisele phambili uphenyo lwethu.
Yes, my lord.
Thank you, Brigadier. Now you mentioned that you could not find any reason why the same photos which were in accused number 3's, which were downloaded from accused number 3's phone, could be in Kelly's phone. You could not find a reason for that. That's what you just said.
Uthe wena anzani ukwazi ukuthola isizathu sokuthi yini indaba izithombe ezikwazi ukutholakala efonini kaMsola wesithathu zaphinde zabona zisefonini kaKelly Khumalo.
Yes, my lord, but I'm referring to that in the context of the reasonable explanation. For example, let's say a similar picture is found between me and my colleagues who works with me. The reason could be that we've exchanged it. We've sent each other because we work together. I'm referring a reason in that context that I could not find a reasonable explanation in the course of the investigation as to why there will be these common features that are appearing, the links that the experts are referring to, my lord. I could not find, in other words, a reasonable explanation in terms of any relations between Ms. Kelly Khumalo and accused 3, as we are speaking about accused 3, my lord. There is no relationship that I found, whether in terms of her profession or his whereabouts, in terms of where he come from, homeland, phosphorus. I could not find anything that ties or indicates that these people know each other, and because of that, they could have shared certain things, my lord.
Ukuthi ke phela mina asizange sikwazi ukuthola ukuthi yini umsolo wesithathu enezithombe esifananayo nezithombe esefonini kaKelly, ngoba yabona makuukuthi asithi ke mina kukhona izithombe ezisefonini yami nezomuntu esebenzisana nayo, kukhona ke into engaba isizathu ukuthi basebenza ndawonye, kungaba nesizathu sokuthi mhlambe kukhona izinto ebezingaba semafonini abo bomabili, kodwa ke lana sizange sithole sizathu sokuthi umsolo wesithathu noKelly kanti bahlangana phi, bayihlobo, mhlambe emsebenzini kukhona into esingathi yabaqhuma, futhi nokuthi uhlala phi umsolo wesithathu. Akuzange kutholakale lutho nje olwenza ukuthi sithi kukhona ukuxhumana esingathi kungaba khona ngaleso sikhathi.
Yes, my lord.
Thank you, Brigadier. So, in your quest to try and find a reasonable explanation on your narrative, now, did you ever consider what I referred to you yesterday as a scientific invention being a boon to mankind?
Futhi ke wake wathola mhlambe incazelo yaloko ukuthi scientific inventions is a boon to mankind.
No, my lord. I mean, in fairness to Mr. Minister, no, I did not. But that's not how you investigate. You investigate and rely in the search for the truth. You do your best to find the truth, and with greatest respect, not assumption, because I would have assumed. I did not find. Remember, in this matter, my lord, I brought in experts from who works with cell phones. Now, if that was available for some reason or the other, I suppose then the expert would have said, no, this is the explanation as to why this see-through bag is found in these 3 phones. That's not what was informed, that's not the report I got from them. And I relied on that in moving on with the investigation. That's why I'm saying, other than that, me in the course of my investigation, I could not establish link beyond that as to why there will be this link, let me put it that way, not communication, link. Hence, as I've said, I did not find any relations between Ms. Kelly Khumalo and accused 3.
Yeah, what emsenzini wethu sifanele sizame ukuthi sithole iqiniso, sifune iqiniso, singathathi nje esicabangelayo, ngoba njengoba bengishilo mina ngasebenzisa ochwepheshe la, ochwepheshe bamafoni, and futhi ke nabo bathi mabebheka la emafonini abazange banginike ukuthi kukhona isizathu abanganginika sona esikhomba ukuthi bafanele baqhumene kanjani umsolo noKelly, and futhi akuzange kube nesizathu singathi singinikwa sona esamkelekayo kimi.
That's my answer, my lord.
Thank you, Brigadier. Let's proceed. Now, you had made a number of affidavits. In other words, you have penned a number of affidavits in this case, others with a view to request for certain information, to be allowed to access certain information, the 205 application, the what is known as the 205 applications. Also penned affidavits when you were applying for the warrant of arrest of this accused, not so?
That is correct, my lord.
Athi ke wenza affidavit amaningi lana phakathi kwawo kwakhona nalawe awayicelo zokuthi ukwazi ukuthi ke ufinyelele ulwazi oluthize into enjengamhlambe ke asithi isibonelo lapho ucela ukuthi ufaka izicelo zokuthola ama-205 and okunye ke ilawo ucela khona ukuthi ke ukwazi ukuthi uthole ama-warrant of arrest kusho ukuthi incwadi ezigunyaza ukuboshwa kwabantu athi yebo kunjani.
Thank you. And the basis of those affidavits will be found in the context of investigation also.
Kusho ukuthi izathu zokuthi ufune la ubhalele ama-affidavit kuyatholakala lapho ekuqhubekeni nokuphenya kunjani.
Yes, my lord.
Yebo kunjani.
Thank you. Let us go down the trip memory lane and deal with each of those affidavits that you penned. Now, I'll just give you these papers that I have, just for you to confirm in a general term that these are your statements and everything. You see, I take it. It will be fallacious for me to be expected to say, is that your handwriting? Read back to you, as it everything to you, in terms of what the protocol relating to authentication of statements are. Let us just do it in a very intelligent way. I propose, I'm going to hand to you a document which is supposedly your affidavit. Just have a look at it and confirm whether this is your affidavit. The first document is labeled A333. There it is. Yeah. A333. A333. No, don't read my markings. Just
no. I wanted to read. This is the part with my statement, okay, so I want to read the contents and understand if I make
You can be rest assured I'm not asking those questions that you see being marked.
No, I just wanted to check the contents of it, my lord. Yes, it is my signature, my lord, and those are my details, my lord.
Thank you.
Okay, yebo mina engiyesayindile lapho and futhi ke nemniningwane lapho iyami.
Thank you. Thank you, sir. Thank you. Now, this is a affidavit that was written to support an application that was directed to the magistrate to authorize an application in terms of Section 205. Do you still remember that?
Yes, I remember, man.
Isicelo sokufaka Section 205.
Now, I am just wondering whether I need to read the whole document out or should I just dwell on the portion that I would want us to deal about, or it will be argued that I am ambushing you if I do not read the whole document so that you know the background of the document before I deal with those portions that I would want us to concentrate on. May I request the guidance from the court, madam?
No, I can't advise. He just told me that you're not going to authenticate the document in terms of the law prescribes you.
I never said that, madam.
I understood you to mean that.
Thank you, madam.
Yes.
Do you recognize this document?
Yes, sir.
The document
Yes, I do, my lord.
Yebo ngiyayazi.
Do you confirm that this document was written by you?
Uyaqinisekisa ukuthi ke le document yabhalwa wuwe?
It was typed and signed by me, my lord.
Yebo i-typo yaphinde yasayinwa yimina.
And do you confirm the correctness of the contents of this document?
Ukuthi ke qinisekisa ukuthi konke kubhaleke kahle ngaphakathi kwale document.
Well, my lord, I'll confirm that it is my signature, but remember now here, my lord, it refers to numbers, for example, of the accused. So I don't have the profiling to refer them to you, but it is me, and I'll assume what I wrote here is correct because I'm the investigating officer, my lord.
Yebo ngizothatha ngokuthi ke imina engayibhala ngoba phela kukhona ezinye izinto ekufanele ukukhulunywa ngazo nezinamba la ngaphakathi.
No, Brigadier. It doesn't work like that. You just heard the court that if I do not properly authenticate this document, then it's going to be considered as a pro non scripto. So I want you to say, with a straight face and say, yeah, no, this is my document. It was penned by me. I stand by the information that is contained in the document. It was commissioned before me, and that is my signature. Otherwise, we will be moving in a. I don't want to be moving on a slippery slope, so to speak.
Angifuni sihambe ngendlela eshibilikayo.
My lord, I agree. This is my statement. I've signed. It was commissioned by me. It was commissioned before me by my colleague. What I'm saying is that the statement refers to certain numbers,
Yes.
and obviously I don't have the profiling to compare if these numbers are accurate. But I confirm it is my statement. It was signed and it was commissioned, my lord.
Ngiyavuma ukuthi statement esami sasayinwa yimina. Ngiyavuma ukuthi sakhomishina omunye engisenza naye. Kodwa ke inamba la ama profile lezi number angikwazi ukuqinisekisa ngawo.
Now that you are saying you are not able to confirm those numbers, how do you then advise that we cross that bridge? Because I want to go into the statement, but because you are saying you're not sure about those numbers, how should you then cross that bridge? Because I don't want later on to come and argue here, with a limping leg.
Manje ke sizokwazi ukuqhubeka kanjani ke nalezo inamba uma ukuthi awusiqinisekisi.
Probably we need to give you an opportunity to go through those numbers and confirm them.
No, my lord, we can proceed. I confirm this is my statement. I signed it. All I was saying, and I'm saying this, I think with fairness, Advocate Lizzie can understand. I do not have a recollection of these numbers vividly to say this number I got it from here, this number I got it from here, because these numbers would have come from profile, because there's a list of cell phone numbers. But I'm not distancing myself from this statement because I signed it and it's commissioned, my lord.
Singakwazi ukuqhubeka kodwa ke ngizama ukuchaza ngalezi number ukuthi phela angisakhumbuli kahle ukuthi ngizothi le number lena ngayithala la, le number lena ngayithola la, le number ngayithola la. Ikona engifuna ukuveza.
Now, I'm also trying to think about the best way of doing it, whether I need to make a copy available to the court so that as we proceed with the statement, the court is also able to follow what is it that we're speaking about and what paragraph are we. Which is the best way? Thank you. I'm informed by my colleague here that I'm advised by my colleague that we can just go through the paragraphs. Thank you. No, just a minute, my lord. Because I don't actually want to continue reading, and the court is not in a position to decipher where am I now reading. So, which is the reason why I'm trying to think in a loud way, the best way of actually to go about.
Was that document not handed up?
No, this one it has not yet. But let me confirm with my colleague. But I don't think so. It has not, my lord. But at the end of it all, after we're done with this document, definitely I'm going to request that it should be handed in, my lord.
It will be handed up.
Yes, my lord.
Okay, fine. You mean after you have said to this witness, he took an oath when signing that document?
Yes, my lord.
He read it, he understood it, and that oath is binding on his conscience. That's what the law prescribes.
Yes, my lord.
Yeah,
Yes.
you must put it to him, because next time I'll be excoriated in the Constitutional Court that I let in a document as evidence when it was not properly before me.
As it is the court, my lord. Thank you, my
Is
lord.
that not so, Mr. Khumalo?
Yes, it is.
Yeah.
Thank you, my lord. Now, Brigadier, this document, it's numbered very accurately. I think the first document is written A333 in bracket 1, the second one in bracket 2, the third one in bracket 3. That is just the Ronio form with regard to the application. Now, your affidavit starts in A333 in bracket 4. Do you see that?
Yabona yini ukuthi ke i-affidavit yakho iqala kahle kahle ku A444.
Now, as I'm saying, you made a number of documents, you've penned a number of affidavits of this nature, but now I am on this one that is dated on the 7th of December 2020.
Manje ngisho sengishilo ukuthi kwenze ama-affidavit amaningi lesi kuyona manje ile kamhla ka-7 December 2020.
Yes, my lord.
Thank you. Now, on page number A333 in brackets 4, let us go to paragraph 2. I'll call it paragraph 2, subparagraph 5. 1, 2, 3, 4, 5, yes. Where it starts with the sentence, the witnesses.
I see that, my lord.
Thank you. Now, it reads there, the witnesses stated that one of the suspects was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or a brown jacket or top and a hat. He was shorter in height than the second suspect.
Yes, I see that, my lord.
Yes.
No, I'll give him. He'll read from mine.
Oh, okay, no, thanks.
Ngifunda yonke. Uthola lapha ufakazi lana washo ukuthi omunye walabasolwa wayephethe isibhamu ekucatshangelwa ukuthi sasiyivolovolo. Lo msolwa lona wachaza njengomuntu onsundu onamehla amakhulu onama dreadlocks egqoke ukhaki noma ibhantshi eli-brown noma i-top no futhi egqoke nesigqoko kodwa lona ke wayemfishanyana kulo msolwa wesibili.
Thank you. This is the description that you are conveying to the magistrate who had to approve or disapprove this application as being what you got from the witnesses, not so?
That is correct, my lord.
Atshile ngazelo lo wayinika emantshi le wathi umufanele ufake lapha wabhala ukuthi ngazelo ukuthi wayenjani lo msolwa wathi yebo unjani.
Is this all that you got, Brigadier Kininda, about the description that you got from the witnesses who were in the house about the description of this person that you are now conveying to the magistrate?
Ikona konke yini wakuthola kuchazwa ababengikhona endlini mayelana nalabasolwa abantu bababona.
Well, I'm not so sure when you say all, my lord, whether is it all in terms of the statements of the witnesses, then the answer is no, because here I was summarizing. It's my statement summarizing what the witnesses have said. It was a summary, my lord. So you were not quoting the statement of each witness verbatim. It's not. It was my statement making an application and indicating what the witnesses have said. So you summarize, my lord.
Cha lokho akuzona izitatimende zaloko okakusho ilaba ufakazi bengitshela konke okwakuphuma emlonyeni yabo lana mina ngangifika nje kuphela lokho engangikuzwile bekusho.
But the essence of what is contained here, it is contained in the witness statements, my lord, that there were two intruders, one had dreadlocks, one was short, one was tall. The issue of the firearm, some witnesses do mention, that's why I said purporting a firearm to be a revolver, because we know that, we've dealt with this issue of the revolver and the expect, my lord. So it's a summary of what the witnesses who were in the house are saying.
Lokho ke okusho lana ukuthi ke kuyafana naloko kuphuma estatementini za labantu ababenginika incazelo ukuthi babenjani abasola estatementini zabo ukuthi ke nje lana kufingqiwe ukuthi ke babe babili nokuthi ke umunye nama dreadlock khona umunye wayemfishane khona wayemude nokuthi futhi ke nalendaba yefolofolo ukuthi ayesesikhulumile ngendaba yefolofolo kodwa lana nje ilento ekuthiwa ngesilungu isamari ukusho ukuthi okufingqiwe.
Yes, my lord.
Thank you, Brigadier. What did the witness who were in the house say about the skin complexion of this person that you are describing to the magistrate in your affidavit?
Manje bathini ke laba ababesendlini uma bechazela ngebala lalomuntu abambona.
My lord, I've indicated that I think about 3 said dark, the other ones did not mention the color, the complexion, my lord. I think we dealt with that point, my lord.
Sesikhulumile ngaleli phuzu ukuthi abathathu abathi wayemnyama and then bese ke abanye abazange baphawule ngebala lakhe.
There was also a mention of dark brown, my lord. So, but the others did not mention that the first suspect was dark in complexion.
Manje kona nje abathi dark brown kodwa ke laba abanye abazange baliphathe noliphathe ibala lakhe.
Thank you. Now, was it by mistake
Kwakuyiphutha yini
that you decided not to tell the magistrate in your application or in your support of your application that this person that I am describing here, I was told by the witnesses, by 3 of the witnesses, that he had a dark skin. The other one, 3 witnesses said he had a dark skin. 1 witness said he had a dark brown skin, and the others were unable to describe his color. Was it by mistake that you did not include that in your confession? I'm sorry, in your affidavit?
Wayiphutha yini ukuthi manje uma ufaka lesi sicelo sakho awuzange uyitshele manje ukuthi ke abathathu bathi unebala elimnyama amunye wathi hayi yena dark brown obanye ke bangaletha incazelo. Kwakuyiphutha yini kwenza?
I'm not sure what we're busy with now, but in any case, the witness says he gives a summary, when making this application to the magistrate. Must he now give such details as counsel would, would like him to have in trying to convey to the magistrate what the identity is all about, just to set out these minute details? We submit, my lord, that this is an unfair question, given the fact that this was just a summary in an application to a magistrate.
Thank you, my lord. It's very interesting, my lord. The objection of the state is based on the fact that it was not necessary for this witness to give those little niggling details about the description of or on the description of this suspect. But now, if you deemed it necessary and relevant to speak about dreadlocks, how could you not have deemed it necessary to speak about his skin color?
manje mawukuthi-ke wabona kusemqoka ukuthi-ke ungakhuluma ngama-dreadlocks yini eyawenza ukuthi kungabi semqoka nakhona ukuthi ukhulume ngebala?
I'm sorry, that is actually a response to the objection by my colleague. It's not a question to him. It's just like that, my lord. That is my response to him, to the state. I'm not so sure whether should I then proceed with my question.
No, the state is just saying, the witness says it's a summary.
Yes.
So the summary of the facts he wants to convey to the magistrate.
Yes, my lord.
That's what he objecting to. That should he now mention each and every detail, that this guy walked with a limp and he was lisping when I spoke to him. That's why he says it's a summary.
My lord.
Maybe let's read, what's the section? Otherwise we're going to be here the whole day again. It's section 205. Let's read it.
I just want to get my from.
Oh, you want your...
No, yeah, I've already discussed.
So that we appraise ourselves as to the requirements required for the issuing of a warrant.
In section 205.
205, yeah.
Yes. But the section reads as follows. And the heading is: a judge, regional court magistrate or magistrate may take evidence as to alleged offense. Subsection 1. A judge of a high court, a regional court magistrate, or a magistrate may, subject to the provisions of subsection 4 and subsection 15 of the regulation of interception of communications and provision of communication related information act number 2002, upon the request of a director of public prosecutions or a public prosecutor authorized thereto in writing by the director of public prosecutions, require the attendance before him or her or any other judge, regional court magistrate or magistrate for examination by the director of public prosecutions or the public prosecutor authorized thereto in writing by the director of public prosecutions of any person who is likely to give material or relevant information as to any alleged offense, whether or not it is known by whom the offense was committed, provided that if such a person furnishes that information to the satisfaction of the director of public prosecutions or public prosecutor concerned prior to the date on which he or she is required to appear before a judge, regional court magistrate or magistrate, he or she shall be under no further obligation to appear before a judge, regional court magistrate or magistrate. Then subsection 2 is really not relevant. Subsection 3, the examination of any person under subsection 1 may be conducted in private at any place designated by the judge, regional court magistrate or magistrate. And subsection 4, a person required in terms of subsection 1 to appear before a judge, a regional court magistrate or magistrate for examination, and who refuses or fails to give the information contemplated in subsection 1 shall not be sentenced to imprisonment as contemplated in section 189 unless the judge, regional court magistrate or magistrate concerned, as the case may be, is also of the opinion that furnishing of such information is necessary for the administration of justice or the maintenance of law and order. Those are the provisions of Section 205, my lord. So in simple terms, to subpoena a person who might have information regarding the commission of an offense.
Is it please the court, my lord? I'm not so sure whether I need to proceed.
Yeah,
where
proceed.
I stop, my lord. Thank you. Now, Brigadier, we are telling the magistrate that may you kindly assist me to get a cell phone records in terms of Section 205, because amongst others, there's a suspect. I'm investigating a criminal case. There's a suspect that is involved here, who is described by these witnesses who saw him as a black male with big eyes, having dreadlocks, wearing a khaki or brown jacket or a top and a hat. He was shorter in height than the second suspect. Now my question is, why didn't you tell the magistrate from whom we are requesting this endeavor to call Rakesh, that this suspect that is also that was seen by these people had a dark skin, had a dark complexion? Why don't you bring that to the attention of the magistrate?
Please, my lord, we have already raised an objection, but we have just read out Section 205. All that the section requires is that the person should have information regarding the commission of an offense. As to this detailed minutiae that my colleague refers to, that is not mentioned in the section.
That is, my lord, that is a very gross misunderstanding of the law. What my colleague has just read now, it has got to do with the person who is being requested to give the information, not what should be contained in the affidavit. This is a directive to the person that what is it that is supposed to do? It's, for instance, in the context of this affidavit, that was directed to Rakesh Ishwaraddin from MTN. Now the investigating officer goes to the magistrate or the presiding officer or the judge and say, can you please order Rakesh to bring this information, because we are investigating, amongst others, a case that involves a person who was described by the witnesses who saw him as a black person, a black male, with big eyes, with dreadlocks. He wore a khaki or a brown jacket or a top and a hat. He was shorter in height than the second suspect. Now my question is, why did he omit to tell the magistrate that the same witnesses who told him that this person was a black male with dreadlocks, wearing khaki, top jacket or hat, he was shorter in height than the second suspect, also had a dark complexion? That's my simple question. Why did he omit to tell the magistrate that?
Yes, my lord. My lord, as I've said, this is a summary. You summarize, that's how Section 205 applications are done. Even when you go for the Section 43 application, you summarize. If you have to include each and every context, I'm not sure how many pages you will write, my lord, because then I'm expected to say, others are saying it's dark, others are saying dark brown, others are contradicting the other ones, others are saying revolver, others, because it's a description of what happened. That's not how you do the application. That's not at least how I know it's done, my lord. This is a summary. It was a summary of what I was bringing to the attention of the magistrate and the reasons thereof. The reasons were the subpoenas of the numbers that were not known to the state when the offense was taking place, and they were subsequently known at the time when I made the application, my lord.
Lana-ke ngangizama ukuthi ngiletheke isicelo esifingqiwe ngoba kwenziwa kanjalo akufakwa konke kufakwa nje into efingqiwe ngoba ngangifuna ukuthi umagistrate azwisise ukuthi ngicelani ngoba kwenziwa kanjalo uma kwenziwa isection 205 noma isection 43 futhi-ke isizathu-ke sokuthi sasifuna ukuthi sithole ukuthi ngoba kukhona lezi namba lezi esathi ngaphambilini sasingakazitholi lezi namba kodwa ngalesi sikhathi sesizofaka lesi sicelo sasesinazo yikho-ke sasifuna ukuthi sicela ukuthola labo section 205.
And my lord, what perhaps should be noted, because I think maybe we are not on the same page with Advocate Mnisi. This statement was not insofar as accused 3 is concerned. So there's nothing malicious to say one was keeping something away insofar as he is concerned so that the court can make a ruling, for example, in terms of the J50. This was an application for section 205. In fact, his number does not even appear on this application. It was simply a background because you need to tell the magistrate what are the allegations and you know the reasons why you want the magistrate to authorize this application, my lord. It's a background, so you summarize. So there was nothing malicious or untoward insofar as accused number 3, because this had nothing to do with him, but it's the background of the case.
Lana futhi kuni engifisa ukuphawula ukuthi lana-ke isicelo lesi sasingahambelani nomsolo wesithathu. Lokhu nje kwakuzama ukuveza ukuthi kuzwakala ukuthi yini indaba sifaka lesi sicelo ngoba sasifuna nje ukuthi kube nendlela ukuthi sendlalele kahle ukuthi kuzwakale kahle ukuthi yini indaba sifaka lesicelo okungaqondene nomsolo wesithathu.
Thank you, Brigadier. You're right. Nothing contained in this document has got to do with accused number 3. All that I'm asking you is why did you not include the description that you got from the witnesses of the skin complexion of this person that you are requesting this, that you are describing to the magistrate in this affidavit? That's all that I want. Let's got nothing. I don't know how accused number 3 looks like.
Ngifuna ukwazi ukuthi indaba ungayifaka ngencazelo ukuthi umuntu onjani umsolo wesithathu muletha lesi sicelo kumagistrate.
My lord, I've answered.
Thank you.
It's a summary. I'm not so sure whether, because I think the term explains itself. When you summarize, you don't take the entire context and put it in a summary. That's exactly what it means. It's bigger, you make it smaller. That's what summary says. So what is initially contained here, on the other hand, when you bring it to a summary, you will not have all the facts. Now I'm getting the question from Advocate Mnisi saying I should have explained as if now we are bringing everything from the top to the summary document. That's not how it's done. When you bring an application, you summarize. You simply give the background and summarize the point that you need to create across and the request that you are bringing before the magistrate, my lord.
Saphinda futhi ngiyasho ukuthi lana besizama ukuletha incazelo efingqiwe ngoba besingafane akudingeki ukuthi silethe isicelo esibhalwe konke ngoba kongeyona inhloso leyo ngoba uthatha okukhulu uyakufinqa kube kuncane. Iyona into esizama ukuyenza ukuthi kuzwakale nje ukuthi sikhuluma ngani kodwa ngingasho ukuthi sizofaka yonke imininingwane ekhona mayelana nalesi sicelo esisifakayo.
Thank you, Brigadier. As we proceed, I must just remind you that this is an affidavit. It's not a summary, it's not an application. I'm reading from an affidavit, but nonetheless, let us proceed. Now, on page 333.5, you kick off by saying your affidavit, by saying, it is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene.
That is correct, my lord. I see that.
Ngicela ngokuthi ke lana abasolwa babaleka bengezinyawo kodwa ke bebaleka isigqoko esasigqokwe omunye wabasolwa sawela phansi.
You further said that the incident took place between, on paragraph 4 of this affidavit, the incident took place between 8:30 and 9 o'clock in the evening, and the deceased was declared dead on arrival at the hospital at 9:15 in the evening. Is that what you say?
uthe wena isahlakalo lesi senzeka phakathi kwamahora ka-8:30 no-9 wasebusuku nokuthi bafike esibhedlela ngo-9:15 akunjalo?
Yes, my lord, that's what I'm saying. Even the top part of the head being left at the crime scene, it's correct. It's contained in the docket.
Yeah,
The declaration of the deceased, when they were declaring him dead at 21:15, it's in the docket. That is correct, my lord. And the estimation, because this 9:30, and it appears in the numerous times in my statements, that is between 20:30 and 2100 hours, because you have to take into account the call in which the first responders receive, and when they arrive at the time. So that's how you calculate it. So yes, that's what I've said, and that's what is contained in the docket, my lord.
Yebo kunjalo ngoba bafika nasesibhedlela basho ukuthi ushonile ngo-9:15 bathi ukuthi ushonile. Yebo lamahora abenjalo ngoba kwavela ukuthi cha kwakuyizo lezo ikhathi zika-8:30 no-9 wasebusuku.
Now, you go on, you proceed in paragraph number 4. Paragraph number 4, subparagraph 2 thereof says, investigation which resulted in evidence under oath revealed that the victim was murdered in a contractual assassination or hit rather than a robbery or a robbery gone wrong.
La yachaza ukuthi umufi lo wabulawa ngabaqashe ukuthi bombulala nokuthi kwakungekona ukuthi wadubuleka ngesikhathi bezaba ukubamba inkunzi.
Yes, that's what I said, my lord.
Yeah, we're going to ngishilo.
And is this evidence that you had when you applied for this, when you wrote this affidavit in application for in preparation for the 205 application?
Manje yiloko awona ngesikhathi ubhala ke le affidavit sifaka isicelo sika 205.
Indeed, my lord. Yes, I had this application, because if you look at the commissioning date, it's dated 2020 December 07. The accused were already arraigned even that time. They already made their first appearance in Boksburg.
Yebo kunjalo ngoba uyalibona nosuku olubhaliwe lapha ukuthi abasolwa abasisebeboshiwe sebeyovela enkantolo eBoksburg.
So you basically are saying to the magistrate that no, this was a contractual killing. It was actually not a robbery or a robbery gone wrong, as the office of the DPP has mentioned in their summary of substantial facts. Not so?
We're going to rise for the last time on this aspect, and you know, we don't want to interfere with Advocate Mrs. cross-examination, but we submit with the greatest of respect that, you know, we're splitting hairs here. I think this line of cross-examination, and we say this with the greatest of respect, demonstrate a fundamental misconception of Section 205. Section 205, it's aimed at, actually states on there are two jurisdictional aspects regarding Section 205. Firstly, there has to be evidence that an offense has been committed, and secondly, that the person who's been subpoenaed has got that information. So those are the only two jurisdictional aspects that trigger Section 205, namely that an offense has to be committed. The affidavit says that an offense has been committed, and secondly, that the person, the service provider, is in possession of that information. Cell phone records are required to determine if what in or Section 205 records, cell phone records are needed to determine what role any cell phone communication played. This is not a trial before a magistrate. The magistrate is not required to as it were, he's not a trier of fact. All that the magistrate needs to convince himself are those two jurisdictional aspects, that an offense has been committed and the person from whom the information is required is in possession of that information that can help to resolve the crime in question. Those are the only requirements of the section. What my learned friend is busy with, my lord, will be absolutely of no help as far as Section 2.5 application is concerned.
Is it please the court, my lord? I'm at no point, not even with a bit of an inch, am I challenging the validity of this Section 205. That is not my aim, and I will never do that. However, it should be borne in mind, my lord, that this Section 205 is based on certain information that the magistrate is being provided with, which information stems from the investigation that is contained in the case docket. Unless my colleague says to me he's not feeling comfortable when I'm raising what is contained in this affidavit, which is accompanying. It's an application. How can I put it? This is an affidavit in support of the application of the Section 205. Unless my colleague is saying that I should not actually question this affidavit because as is, it is as is. But it is not as is, vis-a-vis what this witness testified about in his evidence. Remember, he is the same witness, my lord, who penned this statement, this affidavit under oath, which facts he got from his investigation. So there's therefore nothing wrong with me when I take him through what he presented to the magistrate, which is exclusively based on the nature of his investigation. I'm not challenging the validity of the Section 205.
So what are we about if you're not challenging the validity of the information which was acquired?
Contradictions. I'm about contradictions.
What type of contradictions?
Contradictions that will enable the court later on to decide whether he's a credible witness or not.
Let's see.
Yes, my lord.
Yes, let's hear.
Thank you, sir. Now, you are saying in your affidavit that the evidence which you heard under oath revealed that the victim was murdered in a contractual assassination or a hit rather than a robbery which has gone wrong. Now, before you answer, let me complete my questioning. Are you aware that what we have just said here totally contradicts the summary of substantial facts that are contained in the indictment? That you are saying this was a hit when the summary of substantial facts are saying that this is a robbery that went wrong. And in fact, you are saying, sir, it was a hit and not a robbery which has gone wrong. Do you see that?
Well, again, my lord, we want to rise on a different aspect, and we'll find authority to this aspect that the motive for the commission of an offense need not be disclosed by the state in the formulation of the charges. So whatever the motive was for the commission of the offense is irrelevant. If someone has been murdered, what the motive thereof was, my lord, is absolutely irrelevant. The fact of the matter is that murder was committed. We submit, therefore, that what my learned friend is trying to elicit from this witness is it's not in keeping what the law says. It says motive for the commission of an offense is irrelevant.
As it is the court, my lord. Again, I submit, my lord. That is a dire misunderstanding of the Criminal Law Amendment Act what is that act now that deals with the minimum sentences? The Criminal Law Amendment Act 105 of 1997, yes. That act is very specific, my lord. And subsequent to that act, so many authorities have come. And if my colleague says that in the indictment you don't need to put a motive, as I'm saying, it's a misunderstanding of the law, my lord, because you need to put in the indictment information that will enable the accused to plead thereto, to enable him to conduct his defense in terms of what the charge sheet says. But nonetheless, my lord, I'm not talking motive here in my cross-examination. I am simply bringing it to the attention of this witness that is he then aware that what he's telling this magistrate, he's saying to the magistrate, look, this was a contractual assassination. He has said he does not know why Kelly would have wanted to kill Senzo because he has not investigated that. But all that he knows is that this was a contractual assassination. But the summary of the substantial facts are saying this is robbery or a robbery which has gone wrong. Now I am saying to you, are you then aware that you're basically negating what the summary of substantial facts contain when you say, no, this was not a robbery or a robbery which has gone wrong, but it was a contractual killing? Is he aware that he basically negates what is contained in the indictment? That's all that I'm asking him. I'm not talking motive. I also don't know why Senzo was killed. He also has said that he does not know why Senzo was killed. Contradictions. Thank you, man.
My lord, I'm not sure. Should I answer? Should I respond? I don't know. My lord, look, if I have to comment, firstly, to say or to make an assertion that this statement A333 contradicts what I've said in my evidence in chief is not correct, because it is in line with what I've said. That's number one.
Sorry, Brigadier. Just to correct, I am not saying it contradicts your evidence in chief. I say it contradicts what is contained in the summary of substantial fact in the indictment, not you.
Oh, I thought it was directed to me.
No,
Okay, all right.
It was not directed to you.
All right, okay,
Yes.
then I misunderstood. My apologies.
Thank
Secondly, my lord, the issue of the paragraph, the one that deals with the contractual killing rather than the robbery gone wrong. I think it's in. Just want to find it, my lord. But basically, the paragraph that refers to.
Sorry, Brigadier. I realize that it's almost 1 minute past 1. If you want to go through that, I can request an adjournment. Then we go on lunchtime, and then the meantime.
No. Let me just
put. You come and respond to it when you come back.
No, let me just put it. Let
Oh,
me
you
just
want
deal
to
with
finish
it. Yeah,
it?
let
Okay,
me just
that's
deal
fine.
with it. It will be
Yes.
short, my lord. What I'm saying, my lord, is that the paragraph that refers to the incident being a hit rather than a robbery gone wrong. I also dealt with it, my lord, when I applied for the warrant of arrest of the accused. And the application for the J50 is dated 23 August 2020. This is before the warrants were authorized. So it is not a new thing. I've dealt with it right from the beginning, going upwards. I've never kept that part away, and that is because the investigation revealed such evidence. So it is not for me, my lord, to take left when evidence is pointing me to right. That's the second part. And thirdly, and I've said this, my lord, I cannot speak on behalf of the NPA. I think the powers there are clearly separated, and I'm not the one who can answer to that. I can only account to what was contained in the docket and what I presented to the magistrate. Now, if I had went to this magistrate in Johannesburg and presented facts which are different to what is contained in the docket, that would have been a crime, my lord. I could not say when evidence sitting before me indicates that this was a contractual killing, then I say something else. This was based on what is contained on the docket, and I presented these facts as they are. That's the truth, my lord.
Thank you, madam. May I request for an adjournment for lunchtime? Thank you, madam.
Affidavit that is being used currently, the defense indicated that, Advocate Nisi indicated that would like to hand it up. The last exhibit was the W series, but we just want to keep it together with the previous affidavit of Brigadier Gininda that was handed up in the trial within a trial. Just looking for the reference to that affidavit. I think it would be Linda. Anyway, we will come back to it just now. Just before we adjourn, my lord, we just wanted to make quick 2 points. And the first one was that my colleague referred to the issue of intention, the minimum sentence legislation, and said, and said the state was misconstruing the issue of motive. We submit that motive and intention should be distinguished. What the minimum sentence legislation is referring to, it's intention, not motive. And we mentioned, my lord, that motive as well as the commission of the crime should not be conflated. And just briefly, Stayman's Criminal Law, 7th edition, says at page 169, intention must not be confused with motive for committing the crime. In determining whether acts acted with intention, the motive behind the act is immaterial. And just secondly, my lord, these issues that we're debating are the issues which at the end of the case, the court will have to make a finding on. So we are in our submission, my lord, that we're dealing with or we're arguing the issues that should be argued at the end of the trial and not at this point. Thank you. The last exhibit of Brigadier Gininda was exhibit ZZ. Maybe we can make this exhibit ZZ1, okay, just to keep them together. Thank you, madam.
Any response about section 51, 1 and 2? Yes.
Thank you, my lord. Thank you, Brigadier. I am just trying to find out if I'm done with ZZ1, the statement that we were busy with before we went on the lunch break. you. It's just a general question. It came many a time in your evidence in chief. You kept on saying that Kelly, there are numbers of a cell phone that Kelly did not disclose to the police, not so?
That is correct, my lord.
So khona inamba ezingavezwanga emaphoyiseni athi yebo.
It sounds to me like if that is really a correct statement is put the way in which you are putting it. In other words, Kelly willfully, and I said I'm not here to plead her case, but then Kelly willfully held the information from the police.
Well, indlela engala ngayo ngathi uthi uKelly wafihla ngenhloso ulwazi oluthize emaphoyiseni.
My lord, I'm not sure how should I answer that because the context in which these numbers were discovered through the expert is that they were active and they were being used on that day. So I'm not sure anything else I'll be speculating. What I know is that they were active and they were not disclosed to the investigation team at that time. They only gave 2 numbers. Those are the facts in the docket, my lord.
Engikwazi ukuthi nje lezi numbers zange zivezwe emaphoyiseni kodwa zokuyinamba ezisebenzayo azizange nje zivezwe emaphoyiseni.
Yes, because I would then have asked you if you've got any form of information or knowledge or even evidence to suggest that they asked her if she's got other further numbers and then she decided to say, no, I don't have numbers except, cell phones, except for the one that I gave you.
Angazi noma unalo ulwazi lokuthi bambuza yena wathi unazo yini ezinye inamba yena ke ungaziveza kodwa waveza nje kuphela athi nazo enginazo.
My lord, I was not there on the first investigation team that was dealing with this matter. All I know is that these numbers were not disclosed, but the details of the interaction of the police officers with Ms. Kelly Khumalo, I think that will be left for them, my lord.
Ngangingekho esikhathi ke ebuzwa kodwa ukuthi bayakhuluma bathini naye. Ngangokuthi mniningwane yakho niyathola.
Thank you, Brigadier. That was just by way of intro, because I got a little bit concerned when you kept on saying that she did not disclose, as if they requested her all her numbers and then she decided to disclose some, not disclose others. But thanks, as you say, you don't know what actually transpired there.
Njengoba ukhuluma ukuthi bekuzwakala sengathi uthakavezanga lo vele kwabasengathi uthi wayenenhloso yokuzifihla lezi namba.
My lord, I'm saying they were not disclosed. I'm not dragging myself to the conversation with the police. If you look at the docket, there's nowhere where they said these numbers were disclosed. They were not known to the police. That's what I'm saying.
Ongisho ukuthi inamba zivezwanga nokuthi ke azizange zidluliselwe emaphoyiseni.
The only numbers that were disclosed insofar as the docket is concerned are the 2 cell phone numbers, the runaway phone and the one that was downloaded. That's what is contained in the docket.
Ngikwazi ukuthi izimbili nje inamba ezalethwa kuthiwa ilenye nale yade download.
Thank you, Brigadier. Now, there's yet another statement, affidavit, which you made. I am just not so sure whether this one was made in application for a certain information to be made available to the investigating team, but it seems to me like it is a standalone affidavit, and it is labeled as page 100 as A198, and it has got 6 pages. It was deposed to. There's a date stamp there. It has got 6 pages. There's a date stamp there. It has actually got 2, the commissioning part, which is handwritten, has got a date of the 3rd of October 2020, and it was done by Detective Sergeant Bibi Mohola. But then there's also a date stamp there, which is dated the 23rd of October 2020, as I read it here, it's from the senior public prosecutor, box back, something like that. I'm not so sure whether you've got it. But the one, may I just show you this one that I have?
No, it's not necessary, my lord. I've got it. That is the.
Oh, you've got it.
I've got it. That is the affidavit in relation to the application of the warrant of arrest for all the accused before court.
Kodwa-ke le affidavit oyibhala angazi noma i-affidavit ingathi i-affidavit eyayizimele and lena i-A198 inamakhasi ayisithupha sengathi-ke lana ya-commissioner ngomhla 3 ku-October 2020 futhi khona-ke futhi nenye-ke idate lapho mhla 23 ku-October 2020 ngathi yayi idluliswe kusina public prosecutor ngicabanga ukuthi wase Boxback siyaphendula ukuthi no yayimayelana nokukhishwa kwama-warrant of arrest kusho ukuthi incwadi esigunyaza ukuboshwa kwabasolwa.
Okay, thank you. Mr. Ramusipil is bringing to my attention that there is an affidavit dated 23 October 2020 as Exhibit ZZ that has already been admitted, my lord. I'm not so sure whether it's this one, because as I'm saying this one, the handwritten date says the 3rd of October 2020, but the stamp which was fixed by the senior public prosecutor Boxback says 23/10/2020. So I'm not so sure which one was admitted. It's the same one. Okay, thank you. That's Exhibit ZZ. Thank you. That's Exhibit ZZ. Ne? Thank you, my lord. I'm told it's already on record as Exhibit ZZ. Thank you, my lord. Now, I would want us to go to paragraph 3. I think now that it was already. I can't remember the circumstances under which.
Just send it up by Mr.
Ngomezulu.
Mezulu when you're arguing that the warrants are unlawfully obtained. Am I correct?
I beg your pardon, my
I
lord.
say Mr. Ngomezulu used to utilize it when he was arguing that the warrants
Correct, my lord.
was incorrect.
That is correct, my lord.
Unlawfully issued, etc., etc.
Correct, my lord.
As it please the court, my lord, I would assume that, very cautiously though, that it has already been authenticated, my lord.
Yes.
Thank you, my lord.
That's why I'm able to quote what it was upended for.
As it please the court, my lord. Paragraph 3.3 of the affidavit. The anti-penultimate sentence of his affidavit, that is the last but one, that starts with, upon the accused arrest, 3.3 in both letters deals with the circumstances of accused number 3, Mr. Mtobisi Prince Mnube. Now,
Correct, my lord.
yes, the anti-penultimate sentence there states, that's last but one, says, upon the accused arrest for a 2015 convicted murder, a cell phone was seized in his possession. Now, the cell phone downloading of his cell phone were done. Now we go to page 4 of the affidavit. It reads thus. The photos found on his cell phone memory showed him wearing the same clothes that were identified by witnesses on the day of the incident, as the accused was in possession of the revolver upon entering the house. He carried the revolver upon entering the house. Are you with me?
I'm listening, my lord.
Thank you, Mr. Nzo.
Kukhona ke umusho lapha owandulela umusho wasekugcineni. Uthi ke lo musho ekuboshweni ke kukaMsolwa ngo2015 ukuboshweni kaMsolwa eboshelwa ukubulala ngo2015 iselfoni ke yathathwa kuyena lesenfoni ke kusho ukuthi kwakhishwa kungaphakathi kwa downloadwa and futhi izithombe ezatholakala kuleyo cellphone zamkhombisa yena egqoke lezi impahla ezakhonjwa ofakazi ngaleli langa lesehlakalo kuthiwa uyena lo Msolwa owayephethe ivolovolo engena endlini.
Thank you, Brigadier. Now, wearing the same clothing that were identified by witnesses on the day of the incident. Let us just pause there. That's the extract that I would want us to concentrate on. Wearing the same clothing that were identified by witnesses on the day of the incident. Thank you. I want us to
concentrate. Ekuyilezi impahla ezazigqokwe ezakhonjwa njengeimpahla ofakazi kuthiwa kwakuyimpahla ezazigqokiwe ngelanga lesehlakalo zigqokwe uMsolwa owayephethe isibhamu.
Thank you. Now, may you kindly explain to this court, when you tell the magistrate that these clothing were identified by witnesses as the clothing that he wore on that day, when did this identification take place of this clothing?
Manje ke lezi impahla leyo kwakuphuma phike wavela nini ukuthi ayigqoke lezi impahla njengoba washo utshela imanje.
So, my lord, I think perhaps we must read the sentence in terms of what he's saying,
Yes.
and then you'll understand, because there's no confusion insofar as I understand it. I'm saying, this is now if you go to page 4, the photos found on his cell phone memory showed him wearing the same clothing that were identified by witnesses on the day of the incident.
Yes.
Witnesses identified that the guy, the suspect with a firearm, was wearing a brown khaki jacket.
Yes.
I've referred to what to those pictures. So if you read the meaning of it, I think perhaps we're reading it in a different context with Advocate Mnisi. There was a description given, a downloading is done, he is seen, and we dealt with those photos where he's wearing a khaki top. That's it. So it's not saying there was a physical identification of the clothing. If you read that sentence collectively, you'll understand the meaning, my lord.
Yebo, la kufanele uyifunde iyonke ukuthi uze ukuthi kuthiwa ngoba vele bese sichazile ngakhombisa mfuni nasisithombeni ukuthi nanga lokho akwakusho lapha kwavela phela eshufonini lesi sithombe lesikhombisayo ukuthi wayegqoke into enje kwakungekona ukuthi kwahamba wayokhonjwa othiwa nanga ugqokile cha ilokho kwavela lapha esithombeni ukuthi wayegqoke lezi impahla lezi sichazwa ebathu mabekhuluma ngazo abasolo zabonakala nasesithombeni.
Brigadier, let me help you. This sentence simply says, upon accused number 3's phone being downloaded, they found certain photos. Those photos were then taken to the witnesses to go and identify the clothes.
That is not what the sentence is saying. The brigadiers explained that it merely says, they describe the clothing in their sentence. I don't know whether counsel wants to take issue with him about what he wrote in his own statement.
I'm not so sure whether I need to respond them because I am reading what is annotated here, what is written here. There is no word description here. It says unless the brigadier is saying now no. It could have been the fact that I was let down by the usage of the terms or English. I actually intended to say the clothing that appeared on the photos that were downloaded on the cell phone memory fit the description. Is that what you intended to say, Brigadier?
My lord, in English you get synonyms. One way it may be interpreted in a different way. I've explained what I meant. There was no identification of clothing and the docket speak itself on the day of the incident. What was given is the type of clothing the perpetrators were wearing. Now I've said if you take that to the downloadings, and I've testified about it, that there were similarities in terms of the jacket, the top, the brownish khaki jacket worn by accused 3. That's what this sentence means. So if Advocate Nisi wants to interpret the weight identification as being a physical identification, that's why I'm saying that's where we're not finding each other, because that's not what I've meant here. I said this. I've drafted this affidavit, and that's not the meaning that I had in mind. What I meant is there was a description, perhaps to use this term, given by the accused as to how the first intruder was, what he was wearing, and the type of the clothing that he had. Fast tracking to the downloading of the cell phone, a similar clothing is found fitting that description, if I must use the term, so that we agree. Not necessarily that there was a physical identification of clothing, my lord.
Manje ke ngifuna ukubeka lana ukuthi ke kukhona amazwi amagama athi umesetshenziswa kube amagama asho into eyodwa. Kodwa ke amagama ebengizama ukwasebenzisa la befuna uzama ukuchaza ukuthi yebo kwaba nencazelo yabantu abachazayo ukuthi umuntu ayigqokeni. Uma sesiyake ezithombeni sifike sithole izithombe ezina lezinto lezi achaze ukuthi wayezigqokile. Angasho phela ukuthi bengafuna ukuchaza ukuthi kwaba khona ukuthi umuntu amiswe lapha kuthiwa khomba ukuthi yini la igqoke ukuthi nange uye lo ogqoke le yanto. Kodwa ke ngisho ukuthi ke sasiphela sasiqhathanisa lokho kwakutholakala ezithombeni nalokho okuchazwe yilabantu ababesifakazela ababofakazi.
Thank you, Brigadier. I won't take issue with the usage of terms like identification and description. At least now you are explaining it, that you actually meant to say description. But when I read it, I said identify. Identify means you just go and have a comba thing, like to go and point it out. Do you understand? But thank you for the explanation. It eases my mind.
Understood, my lord.
Thank you. Now let us proceed. Photos downloaded taken of the accused by himself, open bracket, selfies, close bracket, matched the description of the suspect who had the firearm with dreadlocks, big eyes, and with the gold teeth.
Izithombe ezadownloadwa kule phone ithombe ezazithathwe umsolwa ezithatha yena ngaleli gama elisetshenziswayo kulamalanga kuthiwa yi-selfie ezifana nalezi ezazichazwe la kwachazwa khona ukuthi umsolwa owayephethe isibhamu wayenama-dreadlocks enamehlo amakhulu and futhi ke wayenegolide emazinyeni.
Yes, my lord, I'm listening.
Thank you. Now let's go to the, I think it's Exhibit S, isn't it? The downloaded pictures.
Yes.
Pictures of the downloading, yes. Now, I am going to request you to meticulously go through Exhibit S. As I told you initially, said that this is an affidavit, and you really would understand better as a manager in SABC what an affidavit and what is it that is being said in an affidavit entails. But having said that, let's go to Exhibit S. You take us to those photos, those downloaded photos that were taken by the accused himself with dreadlocks, big eyes, and with the golden teeth. We can request the state to page for us on the accused persons can also follow. Start with the first picture.
Yes, my lord. So which
Yes.
part do you want me to describe? All the pictures that are now under this exhibit.
Okay, let me leave you to do your own identification of the picture that has the accused, that has the suspect, who is now said to be accused number 3 with dreadlocks, big eyes, and with a golden teeth from the downloaded pictures. That's the information that you told the magistrate.
Yeah, so my lord, firstly, so I'll identify those pictures. But firstly, remember, sorry, my lord, my apologies. What I wanted to say, this is a summary, it's a collective of pictures that were taken with dreadlocks, and others are showing, obviously, the clothing, as I've indicated, my lord, and others which I've identified and dealt with them during the evidence in chief. In particular, photo number 15, and I've dealt with photo number 15, where I said, this is the accused with the gold teeth incision. I even said, my lord, when there was seemingly a concern about it, I said, because of the angle, I'll understand the concern of the accused. But myself, this is a photo where I said it resembled accused 3 with the gold teeth incision on the upper lip. So that is insofar as the gold teeth. The others, my lord, we've dealt with these pictures, like the first one that we dealt with, where he's wearing a khaki top, the dreadlocks are there. Yesterday we dealt with the length of the dreadlocks on different angles. We've dealt with these pictures, my lord, on various occasions. So I'm not sure. That's why I'm saying I'm not sure whether I should go back to it. This is the one with the gold teeth incision, called number 15, which we've dealt with. So this part of my affidavit referred to these downloads, my lord, because by the time I made this affidavit, I had these downloads in my possession, my lord.
Lana khona bengikhuluma ngezithombe eziningi la kubonakala khona ke nalesi sithombe number 15 la kubonakala khona ke izinye negolide elungumsola wesithathu ngase ngaphinde ngachaza futhi ukuthi ke ngendlela ke okuthathwe ngayo ngeengeli ekuthathwe ngayo mhlambe ke kungaba nenkinga ukuthi bonakale kahle kodwa ke ezinye izithombe zikhona lapha nale izithombe ezikhomba ukuthi unama dreadlocks amade kangakanani nezinye izithombe kodwa bese sidlulile kulezi izithombe nezincazelo zazo.
And with regard to the selfies, my lord, the report I got was that the photos were taken from the device itself. This is now from the forensic team. And I remember I was shown that the email number of the said device that was active in 2014 was the same handset in terms of, if you follow the email reference that I've checked myself, that was downloaded in 2015. So in other words, if you take the downloading, the details of the cell phone, the handset that was downloaded in 2015 after it was seized, it's alleged that it was seized from accused 3. If you look at that identification in terms of the email number and you move it back to 2014 in October, particularly when we managed to get hold of the section 205s, because you can see the email number. If you read that email number, which at the time we didn't even have, but suppose that the experts were able to say these photos were taken by the handset, meaning the owner of the phone would have used the same camera in essence. And I can say I've collaborated that, my lord, on my own. When the 205, first we had the 205 that starts in November, which indicates 2014 that the handset was not changed. But going backwards, even to the ones that came while this court was in session, which covers the period of this incident in October 2014, even then the handset is still the same as the one that was downloaded in after it was seized in Feb 2015. So I'm referring to the issue of the selfies to say this is a report I've got, but it was supported by documents that I've checked in terms of that unchanging chain, my lord.
Malana nezithombe udathatha zona ama-selfie la ayethathwe ngayo le cellphone le eyatholakala noma eyathathwa kumsolo ngoba kuthiwa le cellphone yayisebenza ngo-2014 and futhi-ke nokuthi-ke uma kukhishwa lama-download lawa akhishwa kuyona ngo-2015 ekhishwa kuyo le phone le ethathwe kumsolo ngoba-ke lokho sakwazi ukuthi siqinisekise emva ukuthi-ke siyocela i-section 205 ngoba i-section 205 yaveza konke yaveza ne-IMEI number ekhombisayo ukuthi lezi iy'thombe zazithathwe kuyo le phone lena evela lapha ngale IMEI number.
Yes, my lord.
Awukahle brigadier. Hayi na. Ngiyashiyeka impela. In other words, it means I'm getting lost. Now let's do it like this. I can understand it's been a very long week. Yeah. But let's do it like this. This, it's a supposed situation. Now, this is the magistrate. It's reading your, and by the way, in terms of how affidavits are made, when you refer to something like a photo and stuff like that, you need to touch it as you need to affix it as an attachment, like exhibit A, B, C, and all those things. You understand? When you refer to a photo with maybe a person who has got dreadlocks, you attach that photo. See exhibit A. You see, that is how affidavit works. But let us do it this way. Now, there's a magistrate that is reading this paragraph, and you are saying to him, photos that were downloaded, taken of the accused by himself, in brackets, selfish. I'm sorry. I'm sorry, my lord. Matched the description of the suspect who had the firearm with dreadlocks. Now the magistrate would say, okay, this suspect who had a firearm, how did it look like? That's not his business. The magistrate. With big eyes. How did these eyes look like? That is not his business. And with the golden teeth, it's not his business. But let us assume, in an imaginary situation, the magistrate, hey, Brigadier Kininda, come. Bring that, bring those downloaded photos. And then the magistrate says to you, okay, show me the photo of the person who has got dreadlocks, big eyes, and with a golden teeth. And we have got exhibit S before you. Which photos would you have shown that magistrate to represent this description from exhibit S?
That's a good place, my lord.
Once more, we really don't know what the basis for these questions are to the witness, and you know, we'll briefly refer to section 43 in terms of which, you know, a warrant is applied.
Yeah, just read it.
Yes, section 43 reads as follows. The headings: warrant of arrest may be issued by a magistrate or justice. It says any magistrate or justice may issue a warrant for the arrest of any person upon the written application of an attorney general, a public prosecutor, or a commissioned officer of police, as in the case of Brigadier Gininda. Subparagraph A, which sets out the offense alleged to have been committed. B, which alleges that such offense was committed within the area of jurisdiction of such magistrate, or in the case of a justice, within the area of jurisdiction of the magistrate, within whose district or area application is made to the justice for such warrant, or where such offense was not committed within such area of jurisdiction, which alleges that the person in respect of whom the application is made is known or is on reasonable grounds suspected to be within such area of jurisdiction, and subparagraph C, which states that from information taken upon oath, there is a reasonable suspicion that the person in respect of whom the warrant is applied for has committed the alleged offense. The rest of the subsections relates to jurisdiction. I'll just quickly read them. Notwithstanding any other law, an application for a warrant under this section in respect of the offenses listed in subsection 21(1)(a), A to D, may be made to any magistrate or justice, irrespective of whether or not the place of execution of the warrant or the place where the alleged crime has been committed falls within the jurisdiction of such magistrate or justice. In subsection 2, a warrant of arrest issued under this section shall direct that the person described in the warrant shall be arrested by a peace officer in respect of the offense set out in the warrant, and that he be brought before a lower court in accordance with the provisions of section 50. And lastly, subparagraph 3, a warrant of arrest may be issued on any day and shall remain in force until it is cancelled by the person who issued it, or if such person is not available by any person with like authority, or until it is executed. So this details that counsel is asking from the witness. It's not what the law says. The law is straight to the point. There has to be evidence under oath that there's a reasonable suspicion that the person for whom a warrant is sought has committed the offense. That's all that the section requires.
As it please the court, my lord, this has got nothing to do with the warrant of arrest. This has got everything to do with the description of the person as described in the affidavit, which affidavit refers to Exhibit S. I'm not in the warrant of arrest. And for that matter, the warrant of the section that my colleague has read says the reasonable suspicion that the person against whom the warrant of arrest is being applied for has committed the offense. Now, what this application seeks to say, it simply means that the person that I have referred to in paragraph 3 as Mr. Mnube has committed these offenses. Amongst others, he has been is proved that he has committed this offense. He is being identified by the witnesses through these features, and these are those features. That is where I am, my lord. Warrant of arrest, I don't attack the validity of the issuing of the warrant of arrest. And I've indicated at the very onset of this, when I introduced this affidavit, that I do not know for what purpose this affidavit was penned for. Brigadier Kininda said when it was applied for warrant of arrest. No, warrant of arrest is fine. Their validity is good. They are not at issue here. I am simply requesting this witness, my lord, as he is saying that the photos, his description of the suspect in the affidavit matches some of the description that are mentioned in Exhibit S. Now I'm saying it to him. Can you please marry what is contained in your affidavit with what is contained in Exhibit S? I don't know what is the difficulty with that. I don't know. If he is unable to marry them because they are not marriable, he can simply say that. But if he's able to marry them because they are compatible, then there he is. He should continue to do that. But warrant of arrest, no. I'm not there. When I make mention of the fact that, let us say that the magistrate is here and then he says, can you help me? I said, let us suppose. I was just trying to simplify things.
Does the law stipulate that?
Stipulate what, madam?
What you are saying? Let's suppose the magistrate is here. Does it stipulate that the magistrate must or shall?
No, no.
So what are we talking about? Let's talk about the law.
It doesn't, man.
Because
Yes.
I'm here for the law.
Yes, my lord. Let us exclude that portion.
Yeah,
Then
because
I
I'm
request
included.
this witness then to take me through vis-a-vis his affidavit.
Fine. I don't have a
Yes.
problem with that. As long as you don't involve the magistrate, because that section talks nothing about what the magistrate should do.
Yes, my lord. I am then saying, may you kindly, Brigadier, in humble submission to God Almighty, take me to the photos, or take this court to the photos which depict the person on whose photos were found in accused number 3's download, who has got the dreadlocks, the big eyes, and the golden teeth. From Exhibit S.
ngicela usikhombise lapha ku-exhibit S ukuthi-ke uphi lo muntu kuthiwa watholwa enama-dreadlock enamehlo amakhulu nezinga eliyigolide lapha kulezo iy'thombe ziku-exhibition S.
Clearly, my lord, then I think we must do the whole exercise that I've done, going through these pictures from the first one, because
You're
we've been
welcome.
through, because, yeah, if I can just finish that again,
Oh,
please,
thank you. I'm
because,
sorry,
yeah,
I'm sorry.
because we've been through that exercise. So, but gladly, if the doc can just go straight to picture number 1. But, however, my lord, while he's doing that, you see, this is a problem, and I think this is where we seem to not to find each other with Advocate Nisi. When you select certain portions of the affidavit and not reading it its entirety, that's what creates this misunderstanding, because you need to read what was presented to the magistrate, what am I saying, and what I attach, because this affidavit goes with the indictment. As much as I'm applying for J50, I also refer to the indictment. That's number 1, my lord.
Oqala-ke ngicela ukuthi-ke siye kulezi ay'thombe, kodwa-ke uma sisibuyela lezi ay'thombe kuzochaza ukuthi-ke kufanele ngiyozibukeza zonke lezi ay'thombe ngoba besengichazile ngalezi y'thambo, kodwa ngicela ukuthi-ke uvuma ukuthi ngoba ingathi okwenzayo nje ukuthi uhamba ufike uyokhetha into ethize lapha kwe-affidavit ungavele ufune, ngoba le affidavit ifanele ifundwe yonke ukuthi bengizama ukuchazana ngifuna ukubekani phambi kwemanje.
Secondly, my lord, the affidavit is very clear. It says photos downloaded or taken from the accused by himself or selfies matches the description of the suspect who had the firearm with dreadlocks, big eyes, with the gold teeth. This is the description given by the people who are inside the house. That's why I said it matches. So that's why I'm saying you need to take this thing collectively. But if you're going to take it in isolation, you'll have this misunderstanding. You have to take into account that this description comes from the people who are inside the house. Subsequent to that, you then have this downloading. And this downloading, you don't look at one picture and expect to find everything. It's a collective. That's why I said it's downloading. You look at it collectively. And that is why even when we were dealing with evidence in chief, when Advocate Baloyi was leading me, we went photo by photo. It is not just one specific photo where you expect to find all these things. That's why others have a date of the incidents. Others don't have a date. But what they have, it's what you will find insofar as the similarities that are referred to in relation to accused number 3.
Manje lapha i-affidavit iyachaza ukuthi-ke la ma-selfie lawa ahambisana noma afanana nelezi iy'thombe lezi kuthiwa zathathwa lapha ku-download lapha ey'thombeni ezitholakala lapha efonini kaMsolo, ngoba Ukufana nakhona kuveza phela ama-dreadlocks, kuveza ke amehlo, kuphinde kuveze naleli zinyo legolide. Kodwa ke incazelo lena phela incazelo masithi ziyahambisana kuhamba nencazelo le eyalethwa yilabantu ababekhona lapha endlini ababewufakazi. Kodwa ke ngithi mina ungabheki isithombe esisodwa, kufanele usibheke zonke ngoba nami ngelanga ngizichaza ngayo sahamba savela sabheka zonke iy'thombe. So-ke namanje kungakuhle ukuthi uzibheke iy'thombe zizonke ngoba incazelo lena ayivele esithombeni esisodwa kodwa ivele ey'thombeni ey'ningi ekuvele ukuthi uma sekuhlangana-ke bese kuletha lesi sithombe esibonakalayo ukuthi lo muntu okukhulunywa ngayo wayenjani.
Further, my lord, I'm not done. If you can just be patient with my advocate, Minister. Sorry to interject. Actually, I'm not done. I'll indicate. Furthermore, my lord, insofar as the attachment, and I agree with him, I've seen that, where when you refer to a certain document, you will then attach it, because that's what advocate needs, you will attach it. But in this instance, I was not referring to a specific photo. I'm referring to the downloads. And now the rules of engagement for criminal proceedings and civil actions, civil proceedings, is not the same insofar as I know. Here, when you apply for a warrant of arrest, my lord, you compile your statement as I've done with the DPP. You take the entire docket. You don't attach and direct them in terms of an affidavit. The DPP or the NPA will peruse the docket, make an informed decision based on the docket that is in front of them. And that is the same procedure when I went down now for the warrant of arrest. You take the docket. There is no reason for me to attach, exhibit, because the advocate or the SPP that signed the warrant of arrest is not necessarily Advocate Baloyi. It was the state senior public prosecutor in Boksburg. So he had to acquaint himself with the dockets, reading the docket, and that's how I've been taught. You take the docket, you don't just take a statement and say, here's a statement, I need the authorization. You take the entire docket, the SPP will peruse the docket, and it will be the same if the magistrate chooses to do that, my lord. So that's how it is done. You don't attach things as Annexure A or BB1, BB2, BB3. You may do that, but insofar as the warrants that I know, my lord, you take the docket, and that's what I've done.
Manje ke mayelana ke nezinto ezibekwa docket encwadi njengesithasiselo kusho ukuthi ke uma kuwukuthi ufuna ukuthi ukhulume ngamadocument athize aqhunywa ke kuleyo document noma namathiselwe kuleyo document, yebo uyabhala lapho ngendlela ekwenziwa ngayo, uyabhala ukuthi cha kukhona le engikhuluma ngayo ikhona la, kodwa lana phela bengadingeka ukuthi ngize ngibhale ukuthi cha khona le document kufanele ibheke ngoba uma ngiya lapha ngiyomnika ulona u-NPA noma u-DPP angimniki ama-document athize, ngimnika idocket eliphelele nawo konke okufanele ngaphakathi ukufanele ube ngaphakathi kwe-document. Kwenziwa kanjalo.
Now, my lord, we can then proceed. I suppose we can start with picture number 1. If I can have a highlighter, so then I can refer to the photos that are relevant insofar as accused 3 and this paragraph is concerned, my lord.
Brigadier, I'm not stopping you, but I'm noting something in terms of time. That it's almost 9 minutes to 3. I think this exercise might go beyond 3 o'clock, which is the time at which our colleagues from the different departments needs to go and prepare them. So, you know, others are driving to Morapi prison, others are driving to Joburg prison and stuff like that. At least whilst we are engaging, we also need to have due regard to them, you understand? So I don't think within 9 minutes would have been finished. So that would also give you an opportunity. Look, I want to be fair to you. It's a little bit tedious. It's been a very long week. The mind gets fatigue and stuff like that. But if you're able to go through over the weekends and then you're able to go and prepare this answer again, in all fairness. But again, in the fairness of our colleagues here, it's almost 8 minutes to 3, you see. So we also need to have regard to them and respect their processes as well. Therefore, if everybody is amenable to the request that I'm going to make to the court, I'll be very happy. My Lord, on behalf of my colleagues from the defense and probably from the state as well, may I request that we take an adjournment for the week, for the day. We come back on Monday with fresh minds and we'll proceed with this point when we come back, my Lord. Thank you.
My Lord, if I may say, I obviously I don't have much to say about the request from Advocate Mnisi, but insofar as going through this album, I'm ready. I mean, it's before me. I know what I've done. I do not need time for that. But obviously, if the request is to say we must adjourn to go through them on Monday, it shouldn't be that because I'm not ready. They're here. I know what I've done in terms of the investigation, and I am able to deal with them up to the last picture, my Lord.
Yes, Mr. Malloy, what's saying?
It's a repetition of his evidence. We can carry on until 3:30 if the witness is ready, my lord.
My Lord, to be honest, I've got fatigue. I'm tired.
Oh, you are tired.
Yes.
Okay, he says he's tired. Mr. Namsipidi,
I do not have an objection, my Lord. It's been a long week.
are you tired also?
I'm not tired, I'm focused, but if the cross-examiner is tired, my Lord, we should give him that indulgence.
Thank you, my Lord. I have no objection to the request.
No objection, Lord.
No objection, no objection, tired. We may continue. Mr. Mrs. says he's tired.
Thank you.
So I would have loved us to continue because of our critics who say we are at the slightest drop of the head.
Yes, ma'am.
Okay. So for the reasons furnished by Mr. Mnisi, we shall adjourn until Monday.
Okay, ma'am.
Okay.